Yes. Hello, my beautiful friends. What an amazing day it is today, and a big one. Final decision day from the Supreme Court of these United States. We've got 4 decisions left and a very big one. Trump versus Barbara on birthright citizenship. What does subject to the jurisdiction thereof actually mean? And if you are a non-citizen, somebody who is in the country illegally, do you get the benefit of breaking the law in order to pass citizenship onto your incoming child? We'll take a look at that, and I've got a primer on exactly how these options could flesh out. Of course, we'll have to wait and see what the Supreme Court says. But in addition to that, we've got some other big ones. 2 cases related to men in women's sports, as the president says. The T's going in and demanding equal protection when it comes to athleticism. And then we've got another big one on election spending caps. Can parties be limited or limit others from spending a certain amount of money to participate in elections? And so 4 big ones coming down. We've got SCOTUS blog queued up. And as we know, they will be in and out of the courtroom. We don't need to predict what cases are coming because we've only got 4 left, and they'll all be dropped today. And as I mentioned briefly, we've got these 4: Trump versus Barbara, Little versus Hecox, West Virginia versus B.P.J. These are both the men and women's sports cases. Then the NRSC versus the FEC on the election case. But the big one is Trump versus Barbara, and it is about the 14th Amendment. And so a quick primer on how this whole thing might flesh out for us. So we've assembled here today a panoply, a smorgasbord, a whiteboard of some various options on how this whole thing can come down. So I wanted to run through them so we could ideate what the best possible outcome is, what the worst possible outcome is, and what I think is more likely, something in the middle. But here, of course, we know the 14th Amendment says very clearly, all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. So some pretty big phrases that we're going to spend a lot of time on here today. And of course, the big one is subject to the jurisdiction thereof. What does that mean exactly? So we can define that either in the Constitution. The Supreme Court can come down and say it is constitutionally defined, or they could kind of kick it over to Congress. They could punt it over and they can say, well, this gives Congress the authority to set the jurisdiction. And they've done that. So a couple of options here. One, best possible outcome would be, for our side, that they define it in the Constitution. They say this was already very clear. And the other key phrase is reside, residency. Residency, presuming that you've got lawful authority to be in the nation because you're residing there. You have gotten permission of the state and the country to be in that one particular location. You don't reside in the federal government, you reside in the state. So what would be the best would be this section right here. Okay, the EO is upheld, the Constitution is defined and defining what those phrases are. There were debates about this. This was all litigated when the 14th Amendment was contemplated. There was a senator called Trumbull who said it means not owing allegiance to anybody else. We don't want stateless people. We don't want people without a state. And so if you do have a state, if you do have allegiance to Mexico or Guatemala or El Salvador or Venezuela, then you've got allegiance to them. You don't count for the purposes of birthright citizenship. That would be the best. Now, the worst, the absolute worst for us would be if they define it differently in the Constitution. In other words, subject to the jurisdiction thereof means you're just geographically inside the United States. That means that you are subject to the law. If you're an illegal alien, you come across the border illegally, you commit murder, you haven't acquiesced to the nation, you haven't sworn allegiance or brought yourself under the allegiance of the nation, but we still have authority over you. We still have jurisdiction. We can still charge you with a crime, arrest you. All of that is legitimate. So the goal today is to not get 5 in this bucket. Okay, that would be a disaster. That would mean the only way that we can undo that would be either to change the court and then to reverse this decision in Trump versus Barbara that comes down. So we would need a new court to be consecrated in the future, or we would need a constitutional amendment. So that would be a total disaster. And so the goal is not to get 5 there. We definitely don't want 5 there. We're almost certainly going to get 3 there. So if we had to predict this, we're going to have Ketanji up here on that. We're going to have Sotomayor there, and we'll have Kagan all articulating this position because they want this thing to be ensconced in the law, saying it is permanent. Birthright citizenship granted for everybody, indefinitely, in perpetuity, meaning it's very unlikely to undo that. Now, they may also say that this phrase is kind of handing Congress the authority, like in other locations, like Congress sets the jurisdiction of the courts, for example. Congress can say we need another circuit, we need another federal district court, right? When the courts were first created, we didn't have the Court of Appeals and the federal district courts. These were all kind of brought in after the fact. So what if the jurisdiction is set by Congress? That could also then go over and be delegated out. And if it's upheld, it'll look something like this, that the Trump administration in their executive order was mirroring this U.S. code, section 1401, which articulates already for us a slew of authority on how we contemplate citizenship in America. They already give us the rules on that. So if it is upheld, they could say, well, all Trump is doing is just really pulling from this. This was already defined by Congress somehow. And so it would be valid. Congress defines this, though. They're not, leaving this up to the president to sort of come out with an executive order and define it. Because if Trump comes out and defines it, then we could turn around. The next president comes in and says, well, I think I disagree with that interpretation, and just issues another executive order and then invalidates the Trump EO. Now, more likely, I think, is we'll probably end up in this box somewhere, at least maybe in a plurality decision. We'll come back on that. But if it is not upheld, you can see them making the argument that it's a separation of powers problem, that if Congress does have the authority to set jurisdiction, the president is not the person to define that. And so that would mean that the president cannot define it, Congress defines it, and they would invalidate the executive order such that Congress could come back and redefine it. Now, that would be a loss, but it would not be nearly as permanent of a loss as this box right here. This is the absolute danger zone disaster box. We do not want that to happen at all. And so I could see a plurality on this thing. In other words, they'll say that the EO is invalid, but they won't define it all in this box. So I could contemplate, for example, Gorsuch going here. We could contemplate Amy Coney Barrett going here, which might give you a 5-4 decision. But the reasoning underlying the decision is split down the middle. Okay, so the logic is we don't have a clear answer on whether this EO is invalid, but it's not constitutional. It's not statutory. You could also see maybe John Roberts coming in here. So it's a 3-3 logistical split. And then you've got maybe, Kavanaugh jumping into that bucket. I think Thomas and Alito will probably be up in this bucket right here, but we will see very shortly. So all said and done, if we get 5 over here, we're cooked. So we're going to keep our eye for that on that when this drops. We'll see if it's the first decision or not. Save that to the end just to make sure that we're all a little nervous and quivering in our boots over here. But we're now 5 minutes out and the buzzer has sounded. So SCOTUS blog is in session and we're waiting for them to go into the court and see which one gets dropped. But of course, let me know your thoughts on how you think this whole thing is going to unfold today. Lots of contemplation here. And these are some big ones. So we'll all just take a deep breath. Whoo-saw! And just get ready for a big one. Now, there are also some other possibilities on this, and I'm not so sure that we'll see these, but a plurality decision would mean that we've got, kind of different logic and reasoning underneath. We don't have a clear holding on what the law is. We have a clear holding on what the outcome is, but not the law, which would mean there's a bunch of gray area. And then Congress could, of course, come in. If it is in this column, if it is statutory, Congress could come out, define it, then the president could also agree with that, right? So if Congress defines this and says, yeah, we can, it is statutory. Maybe we lose today. We're in this bottom bucket here. We're going to delete all this in a minute. But then Trump comes out and he issues the executive order that is in parallel with what Congress did. Then now the president is acting at the apex of power because they're endorsed by Congress. In other words, it's two branches that are agreeing on the interpretation, and the Supreme Court would just allow that to happen because it is both, it's basically two in agreement, not just one that is in contradiction to the statute. So we're going to keep this chart here. We're going to see exactly what happens. We'll move the justices around to see where they ultimately end up. But really, there is kind of another, there is another possibility. We could also have these are merits decisions. So we could also have just a procedural kick out. We could see that there was a procedural problem. In other words, the Supreme Court says this plaintiff doesn't have standing or something. So the EO is upheld, and that could be based on something like standing. Or what the lower level court did with their injunction, which was staying the enforcement of the EO. They could say this injunction was overbroad in contradiction to prior cases like the CASA case, and there was no basis to issue this injunction. And so we win. It goes back down, and the lower courts flesh this out more for us. So we could say, nationwide injunctions here, not with a B. Or you could see the inverse of that, right? You could say that the stay is valid, but they kick it back down, goes back down to the lower courts, and they flesh a lot of this stuff out. In other words, they don't reach the merits at all. But we will see very shortly, and it's a big one. And so we're waiting for them to head in there. All boxes, box count really doesn't matter today because they'll all be released today. And we're waiting for this to happen. Let me see if anything else is live right now. We've got Forbes. I wanted to see if anybody was out in front of the courthouse right now, reporting from there. Not seeing much happening. From Forbes, here's how things look in D.C. right now, courtesy of the Washington Monument Tower. EarthCam, nice day right there as we wait for the decisions to drop. And they're building, baby. So the stage is being built right in front of the World War II Memorial, and Freedom 250 is upon us. America's birthday coming soon. Hopefully the Supreme Court delivers us a nice birthday present. So we are now about 1 minute out from the countdown. And they'll be running on in there. And then we'll see. And we've got the judges queued up so we can kind of just move them around. So I would say that we're going to see these three right here. We'll just make our prediction on that one. Seems like a pretty obvious one. And if I had to guess, I think I'd put Roberts down here, saying it's invalid but not constitutional, because he's kind of an institutionalist more than a textualist. I think I would put Alito and Clarence up here, upholding it, saying it's about allegiance and domicile. And then the others, of course, will fit into various categories. So we got the trans cases. First one out of the gates. Justice Kavanaugh with the opinion. We've got two of these, both related issues. One's an equal protection case. One's also introducing Title IX arguments. So we'll save those and allow those to warm up as soon as we get through the Birthright Citizenship case. Now, the holding on this one, Title IX allows schools to provide separate men and women sports teams defined by biological sex. And West Virginia has permissibly maintained female sports for biological females consistent with Title IX. So the T's blown out. Go play on your own teams. Here is the breakdown on this. And it looks like, wow, interesting. Wow, interesting. So we've got Kavanaugh with the opinion, joined by Roberts, Thomas, Alito, Gorsuch, and Barrett. So that is 6 right there. Then we've got a concurring opinion. Sotomayor is concurring in the judgment in part and dissenting in part. So she's halfway in agreement. And then it's basically 6. It's interesting. It's the dissent is kind of agreeing in the judgment in part and dissenting in part. So we'll have to see what that is. And then Jackson also with her own opinion. So Ketanji also concurring in judgment in part and dissenting in part. So we got to look into that a little bit further. But in the judgment, it looks like it's 9-0, concurring in the judgment in part, in which Jackson, Ketanji, and Sotomayor joined. So at least as it relates to the judgment, this looks like it's a 9-0. Concurring opinions, filed opinion as to most of the judgment, but we don't know what they're dissenting about yet. So it might be a different split, but they're joining, concurring in the judgment and dissenting in part. So probably dissenting with some of the logic. But yeah, as it relates to the judgment right there, otherwise they're dissenting. So it's kind of like 9-0 in the judgment and then more like a 6-3 because they are dissenting about something. We'll have to look into what that is. Dissenting in part, those 3. So we'll see what that split is, but very interesting. And then we've also got, let's see. Court holds schools can determine eligibility for women and girls sports teams based on biological sex. Very good. And we thought that was going to be the case. I was kind of curious that we didn't see more from Amy Coney Barrett because she was very unhappy in a prior case that we talked about the T's making arguments that they're like women and they deserve all sorts of scrutiny. So court also says Virginia and Idaho did not violate the Equal Protection Clause, so both cases, by maintaining female sports teams for biological females. Yeah, makes sense. So this is West Virginia versus B.P.J. And we should have the Hecox case as well. This is a 77-pager. Okay, so they combine them. All right, so here we go. So it's actually both cases right here. So maybe that's why we have a little bit of a split. So it's both of these. It's B.P.J. These were separate cases. They're giving us one set of papers that are disposing of both cases. And so we'll get into that one, no doubt, when we see what comes next. Sotomayor apparently agrees that the claim under Title IX fails, although under a narrower basis than the majority. So it fails, but the logic is different. So the holding is pretty consistent across the board. You lose. Even the leftists saying you lose. That's great. That's good news. Yeah, it makes sense. We don't want a bunch of 6'5" dudes dunking on ladies in college sports or high school sports. It's ridiculous. There are biological differences. We've recognized that forever. It's why we treat men and women differently in certain legal contexts, in particular when it comes to having babies and paternity and other things. So, but also says with regard to the equal protection claim, saying that there are still factual questions that prevent the court from assessing the merits of the equal protection claim. So was there some sort of discrimination or something at the lower level if you wade into the facts? But as it stands, the bans are valid. So you can keep them separate, which is a good one. Yeah, one opinion, the case caption listed first at the top of each page. So it looks like this opinion will be referred to in the future as B.P.J. Very similar issues, and I was wondering if that was going to happen because we've got both of these now settled, and it looks like that was Kavanaugh, I think, who decided this. Yeah, so we've got Kavanaugh, 9-0 to the judgment, 6-3 in reasoning, we'll say. So both of those are settled. Now we're waiting for what's next. Lots of people online at SCOTUS blog. Woo. Gorsuch going back into some prior case precedent, Bostock and others noting the differences between Title VII and Title IX. Yeah, Amy, that's what we thought. 9-0 and 6-3, but curious to see what others say. Yeah, 9-0 and 6-3. That's our read. Without having read it, that's what it looks like. So we'll see what's next. Is it going to be election stuff? Or will it be birthright? Probably going to be election. So Kavanaugh still reading right now. And we'll see what comes next, man. Who's got those butterflies in their bellies? I got a little bit of it right now. And we'll see. All right, so we got Fox News reporting on it. They're standing outside the courtroom. Supreme Court upholds state bans on biological boys in girls' sports. Yep. Same on CNN. Analyzing it right now. States may ban trans athletes in girls' sports. That's right. Makes sense across the board. So I think they'll probably save birthright for the end, just to make us all kind of squirm in our chairs for a little bit, which is fine. But it could be a curious one. We might have some work to do to unpack it, depending on whether it's a plurality or a majority. If it's a plurality, like we mentioned, I think that's going to be a new ripe area for a lot of litigation and battling about. But regardless, well, if it is not a constitutional decision, if it's not in this first column here, then Congress may have some say in it. And that would give us an option, presuming that it doesn't go our way, but hopefully it does and we don't have to worry about it. Yeah, is it 6-3 or 9-0? I'd say it's 9-0 in the holding. Yeah, and birthright might be a big fat decision. I could easily contemplate, 150 pages. Maybe more. We'll see. And we're going to go through the whole damn thing. Yeah, is MS Now having a bad day? I don't have that one queued up because they're so obnoxious. Oh, yeah, I do. They're right there. A lot of people outside the courthouse. I don't see any trans flags, though, outside the courthouse right now. Let's see if I can pull something up that's live. And see. All right, we got some Sky News action right here. This is what it looks like outside the courtroom. Let's pop this baby out. Get a little picture-in-picture action going on right here. This is the scene outside the courthouse. Don't think we've got any audio, though. So not too busy. And I know people were having a conversation. Remember when Roe versus Wade leaked? They then had to install all the fencing around the courthouse. So the idea being, well, if it was good for us, in other words, if it was a constitutional argument that says birthright citizenship is only valid for people legally here as lawful permanent residents, or, you know, a even stricter rule, then there would be a leak. They would be very unhappy about that, so that they would leak it. And then there would be a bunch of protests out there and say, oh, they're going to strip away your rights, whatever. And that would be an indicator. Also, basically, that's what happened with Roe versus Wade. They leaked it. Then there was a national outcry. They were hoping that that might shake some people loose. Then they had to install fencing around the Supreme Court. That obviously has not happened today. And I don't mean just these little barricades. I mean like big giant fences. So right now, Sotomayor is, oh, there is some audio. Hang on a second. The Sotomayor is still reading from her concurrence and her dissent.
What organization?
There is a little audio there. Somebody was just cheering about something.
Park in front of SCOTUS. Decision day. Student driver. Right there. Jumped out to get a picture. Yeah, it doesn't get any more student than that. Wow.
Was kind of thinking we'd see more trans flags out there or something. Where'd all the T's go? It's kind of light, actually, relative to some other days and some other opinions that we've seen drop.
Oh, you know one. Oh, yeah.
This, okay, this kind of across
Oh, okay. I was thinking Rebuts.
But yeah, it's across the board right now on the cables. Supreme Court upholds the state bans. Same on CNN. State may ban trans athletes and girls' sports. Same on MS Now. Same basically Chiron across the board. All right, so they're still reading. Justice Gorsuch, they write, with a spending clause argument in his concurring opinion. Spending clause? Like federal funding for colleges and these efforts? And if we're spending money, then we have a say maybe in the policy. Interesting. Gorsuch says, nothing in the Title IX clearly and unambiguously alerts funding recipients that they are prohibited from restricting a school-sponsored sports team to biological women or girls. Got it. Yeah, so if we fund them, then we can attach conditions and limits on the money that's going out to the colleges, and nothing in the grants of the money or the disposition of the funds says anything about being limited from doing this.
You know, saw your mother.
Which makes sense. But although that feels like it means that they could impose those limits, then Congress could come back and say, well, we will attach prohibitions and restrictions to the money, and then that might be valid under Gorsuch's interpretation. We'll come back on it. From Gorsuch. All right. Well, I was going to start reading it, but I don't want to miss anything, you know? So we're just going to hang tight for a second. But in other areas out there, it looks like there are some girls with some signs who are very happy about this decision. Over here, kind of on the left area, this woman's head's in the way. Right here. But looks like there's kind of a bundle of girls who are celebrating this. which is good news. And presumably this is not retroactive. So all of the dudes who beat all the women who are, first place, whatever, that's going to stop, I would presume. I mean, maybe not. Other states will probably continue on with this, but you don't have to. If you want to ban it, you can. Justice Kavanaugh is an avid sports fan who has coached girls' basketball teams for years. And he doesn't want a 6'5" female out there dunking on his players. Makes sense. So he wrote the decision. So we'll see what's coming next, but yeah, so Amy says, or Sarah says rather, there's another case that's very similar to this that's percolating up in the Second Circuit right now. It will be another case, the foundation, and Sotomayor is still reading. Come on, Sotomayor, pick it up. Brought by female athletes arguing that states are required to ban trans athletes, right? So that's going to be an interesting extension of this. Is it an equal protection violation now for women, like the inverse of this? So these states in these cases, they banned the T's from joining the women. But what happens if another state doesn't do that? What happens if another state says the T's can join the women and they are explicit about that? Do the women on those teams have the ability to then say, well, now our rights are being violated? Now, we have an equal protection problem because we're playing with dudes. And can they file a claim to say that they have equal protection under the law and that the affirmative allowance of this should also be banned? In other words, states are required to prohibit this. States are required to ban it. We'll see. Don't know if the Supreme Court will go that far, but we'll have to see what their decision says and what the holding says. Permissive versus mandatory. In other words, states' rights can decide versus this is actually a constitutional claim, and women should not have to, even if a state is permissive in allowing it, have to deal with it. We'll see. So Sotomayor still going through her decision. And she takes forever. We saw this, I think, yesterday. Yeah, I think we're going to get campaign finance next. And then they'll probably save birthright for the very end, which we're cool with. Get the campaign one out of the way, and then, then we'll be going through the big one. All right, let's see if we can find anything else good going on. This is somebody in the UK who's live right now. And we've got, Sky News is live. Fox News just wrapped up that segment. Congress has some activity today. We've got a little GOP oversight hearing. Looks like it's live right now as we're waiting. We got some Newsmax action here. Let's pull this up. See what they're getting into. As we wait. Sotomayor still just reading away.
Did you see this coming? And what do you think of the decision?
Well, yeah, Tracy, I think anyone who can rationally discern a man from a woman saw this coming.
Yeah.
There's no question that the way states were trying to manipulate our laws was favoring people who had no business participating in women's sports. And that was creating not only a legal injury, but physical injury to women as well. So
Yeah.
this is not a surprising decision. This one, I think the Supreme Court got it 100% right.
Yep.
Yeah, absolutely on that one there. Brian, I'm going to go to you next. I'm going to talk about birthright citizenship because that case, we are watching that one very closely. That's about to come down, and this ruling could have some serious implications as well. First, I want to focus on the arguments for it. It applies regardless of a child's parents' legal status in the country, being born in America, making the child a citizen, and the Constitution restricting birthright citizenship very, very narrowly, that is, in the 14th Amendment. Brian, what are your thoughts on these arguments, and could they hold ground
They're crap
for the decision that's about to come down?
Well, look, I think we are, as conservatives, bracing ourselves for what is probably going to be a big disappointment today on this. And I think there's
Stay positive, bro.
Consensus that that's the outcome that's likely. Essentially trying to pull what Trump had been trying to do through an executive order, and that is to change birthright citizenship to where at least one parent would have had to have been an American. And, you know, just taking a flight here and having a baby and then, oh, that baby is now a citizen. I think that's something that has frustrated Americans for a very, very, very long time.
Yeah, because they break the law.
The decision that we saw with Amy Coney Barrett yesterday and some clues today that we're not seeing fencing around the Capitol, right, or the Supreme Court. So that indicates that probably the left has won this one. There aren't going to be any riots. So we've seen that indication, and the lack of leaks, because when the left isn't getting its way on something, they start leaking ahead of time to alert the troops that it's time to riot in D.C. We didn't see those things happen, and we had the huge disappointment yesterday with voting. So between the two, I don't think the outcome is going to be good.
Yeah.
Tracy, can I add
Brian,
a little bit
not
of
to correct you. Yeah, Marley. Yeah, go ahead, jump in there. But we're looking at some images right now, and Brian, I don't know if you see it, but there is, a little bit of fencing up. We saw some police officers out there.
It's just the normal barricades. Those are there every day.
Anticipating potentially something, but you got to be prepared just in case. Marley, go ahead.
Sure. I just wanted to add, that I want to bring up to a lot of people who didn't listen to the oral arguments potentially for the case Trump v. Barbara, because Sauer did an extraordinary job of refuting a very foolish argument that the ACLU basically rested their case on, which is that in determining citizenship, we have to use the British common law definition as it existed before the American founding. Now, I ask you,
it's ridiculous.
If we have to use the British common law definition of a citizen in order to win this case, what was the point of the Revolutionary War? Wasn't it to completely disrupt and rearrange the definition itself of citizenship as compared to under a monarchy into a system where citizens self-rule through elected representatives? So I kind of disagree with Brian. I think that, let's say I pray, and I really hope.
Yeah, stay
that
positive.
The
Yeah.
heard this nuance in the way Sauer argued it, because it's very important.
We're going to will it into existence.
Now, let's suppose that the Supreme.
All right, so they say Kavanaugh has the next opinion, and it's the campaign finance case, which means we're going to have birthright last. And so this one should also be dropping right now. And we'll take a look at what this decision is. 6-3, ideological split. Kagan dissents, Sotomayor and Jackson. Challenge to money limits. Let's see what the holding is on this one and how long this one is. Hopefully they can get through it quickly so we can get to the big one of the day. It's a short decision, 48 pager. So the next birthright case should be here pretty quickly. And that's the wrong link. That's from Watson. That's the link from yesterday. So that's not it. Got a little bit of a wrong link on that one. That was from Amy Coney Barrett yesterday. Very disappointing. But This was a challenge to a federal law that limits the amount of money that political parties can spend in coordination with a candidate for office in 2001 in FEC versus Colorado. The court upheld the limits 5-4. Justice Clarence Thomas, the only member of the court now in the current court, so a lot has changed, writing for the dissent. When this case went to the Court of Appeals, it said, in essence, that the challengers had some good arguments, but that it was bound by the Supreme Court decision in 2001. Trump administration declined to defend the expenditure limits. So the justices appointed a former clerk to Roberts. And the court holds that the law's limits on political parties' coordinated expenditures violates the First Amendment. And that's what we predicted yesterday, that they'll allow the money to be spent because money is speech, according to SCOTUS. And anything that limited it is limiting your speech. So the FEC political party coordinated expenditure limits violate the First Amendment. So get those checkbooks out and spend, baby, spend. It's elections in America. And the holding looks like ideological split. Down here, Kavanaugh joined by Roberts, Alito, Gorsuch, Barrett all joining for the 6, Kagan, dissenting, Sotomayor, and Jackson. So 6-3, another one by Kavanaugh. We'll update our list here. And that one means spend your money. Spending limits unconstitutional on First Amendment. And those dollars will continue to flow. So we'll come back on that. Shorter decision as well, 51-pager. And that felt pretty obvious to us, given the prior holdings, that money is speech that we saw previously. This was a statutory limit, closely drawn. Ultimately, the First Amendment question in this case boils down to whether the FECA's limits on political party coordinated expenditures are permissible in order to prevent circumvention off the base limits on other contributions. So the court agrees that the political party coordinated expenditure limits are not proportionate or narrowly tailored to other less restrictive means. And so we'll come back on that one as well. But that means, my friends, there is one left. We're waiting for Birthright to drop. And so it's just a matter of minutes until they finish reading that decision, and then this will drop very soon. And so the chyrons across the board saying, yep, and the GOP was really behind this effort, so they led this effort, so it's a win for the GOP. They want to be able to spend. Saying the Supreme Court sides with GOP-led challenge to federal law restricting campaign spending. Supreme Court backs GOP-led effort to lift campaign spending caps. And on MS Now, the Supreme Court overturns campaign finance limits, giving power to major party groups. So even more money flying out there in our elections, even more than we had. So if you're just getting here, quick recap. We had good wins on the trans cases. So 2 trans cases were consolidated together. They're both of the trans cases were settled in this one release. So as we saw, both of the cases, Hecox is here and B.P.J. So both of those have been settled already. So we should have one left. My understanding, we'll see if I'm wrong about that, but I think this is both cases, both trans cases were here with victories on it in a 77-pager. So we now should only have one case left, which will be birthright citizenship. Coming any minute, since they consolidated the T cases into one opinion release. So that was good. We got basically 9-0 or 6-3 split on that, on the T cases, which we saw right here, West Virginia and Hecox. So we had one out of Idaho, one out of West Virginia, both of these consolidated. these two cases here. And it was a 9-0 in the holding, 6-3 in the reasoning. And so we'll come back and we'll see what the distinction is. But both of the T cases now settled. This one was also a 6-3, courtesy of Kavanaugh. No more spending caps for the major political parties and their groups, which means we got birthright citizenship coming left. Yeah, and some good comments about spending limits. If disclosures are more evident, then maybe there's really no reason to put limits on it. I think part of the concern becomes when you don't know who's spending the money. Where's all the money coming from? You've got these billionaires just dumping money into these various LLCs and NGOs and 501c3s. Then they all create shell groups and spend on top of each other. And nobody really knows who's paying for any of this stuff. So we'll see if that changes as a result of this. Now, Kavanaugh's close to the end, which means Birthright is coming soon. Birthright next, baby. And we are on pins and needles waiting for it to drop. So we'll just keep it locked right here until it drops. And as a recap on Birthright, we have some possibilities. Will it be constitutionally defined? Will it be statutorily defined? If it is constitutionally defined and we're under this interpretation of the 14th Amendment, and we get 5 justices in this box, we're cooked. So hopefully that doesn't happen. But if they split, if only 3 define it constitutionally, 3 define it as the Constitution delegates the authority to set the jurisdiction to Congress, then Congress can modify it. So we don't want a hard constitutional rule. That would be not good. Unless it's a good constitutional rule. But I've got my doubts that that's going to happen because our Supreme Court tries to thread the needle with people like John Roberts, as we saw yesterday, wants to keep things kind of even Stevens in, middle down the line on a couple on major issues. So Sarah says, Birthright is next. Been waiting for this moment since January 25. Tell me about it. After Trump's EO, we knew it was going to be a Supreme Court case. And it's a big one. I think it changes the fabric of the entire nation. What kind of sane nation would allow foreigners to come in who don't actually live here, drop babies off at Have My Baby in Miami in Florida, a literal company that does this by trade, brings them in, drops the baby off, boom, you're a citizen because you just happen to be geographically born here. And then you get the benefit of the rules. And we have birthright citizenship. Whoo! Let's see what we've got. So we're going to dive right into this as soon as it drops. They're reading it on the bench right now. And hearts are pounding. The court strikes down the executive order, which is not good. So the EO is unconstitutional or it's illegal in form. And so birthright citizenship in its current form looks like it remains. Oh, we're getting blown out, man. It might be the worst box of them all. 200-page decision. Wow. It looks like Roberts and Amy Coney Barrett joined in with the leftists. And I think we're in the worst possible box. We just got backstabbed. Roberts delivers the opinion of the court. He's joined by Sotomayor, Kagan, and Barrett, and Jackson. What a disaster. So I think we're in the worst possible box that we could be in. What a joke. So held, children born in the United States to parents unlawfully or even temporarily here are subject to the jurisdiction of the United States. We just got obliterated by a conservative Supreme Court. We got crushed. They are citizens at birth under the 14th Amendment's Citizenship Clause. So as we mentioned, they are in this box. So let's just show you what happened right here. It's under U.S. law. This is the breakdown right there. We got blown out, which is a total disaster. All right. We could have lived with a loss over here, but this is the decision. And we had Roberts and Amy Coney Barrett do this to us because they can't understand subject to the jurisdiction thereof. They're going to interpret it to mean you can be in the country literally illegally, okay? Illegally. And they're going to define this as just a geographic limitation. What an absolute disaster this is. It's the worst possible outcome, I think, that we could have. So what do we have in the dissent? Now, Kavanaugh concurring in the judgment and dissenting in part. So he agrees with the outcome, but not the logic underpinning the outcome. So you could even call that a 6-3 if you want to. 6-3 in the holding. What a disaster. We've got Thomas with the dissent, Gorsuch joining that, Alito and Gorsuch filing dissenting opinions. So 6-3 in the holding, really 5-4 looks like in the rationale, but this is going to be the one that matters most. So, oh gosh, what a disappointment. So Kavanaugh, you know, he might be more over kind of in this category. We'll see what his rationale is. But we've got up here the dissents. We really don't know what they're going to be saying. They could be up here that, you know, they would have upheld the EO, whether it's constitutional or statutory, we don't know. But we're cooked. Yeah, we're cooked on this issue. Yeah, we're cooked. So here is what it says once we get into it. And Chief Justice Roberts is going to deliver the opinion. We're going to spend a lot of time on this here today. Roberts delivers the opinion of the court. The question: does the Constitution guarantee citizenship to children born of parents illegally, unlawfully, or even temporarily here? Which means you fly your Chinese baby into the United States in Miami, boom, you're here for 5 minutes, you're a citizen. 14th Amendment, as we talked about, says all persons born or naturalized in the United States and, okay, and did they miss a comma right there? I mean, did they just quote this missing a freaking comma? Oh my goodness. All right, let me just show you this. This is from, this is from right here, Constitution annotated, okay, constitution.congress.gov. All persons born and naturalized in the United States, comma, see that comma right there? And subject to the jurisdiction thereof, meaning it's a conjunctive phrase, it matters, and that, comma, are citizens. Did I just gloss over that? They missed a comma. Oh my gosh. All right, so you can see there's like literally no comma right there. In the where's the comma? Here is that one. They're missing this comma right here. So it's like embarrassing. Somebody didn't even proofread it. There are two commas. This is a separate phrase. That's what those commas signify. It matters. It makes it a separate condition. You have to, it's not just being physically plopped down here and born. I mean, unless this is wrong and the Supreme Court is right, but this is Constitution annotated. This stuff matters so much. This makes it a phrase that is a secondary condition. It's and it has to be both of these things. If you delete the comma, It makes it less critical. It's just, if you're born here and subject, whatever, it's a separate conditional phrase that they're just glossing over even in their quote. They can't even quote it right. Oh my gosh. He says, all right, thank you, John. Go back to your proofreader. Go back to your clerk because they can't even get a comma. On January 20th, Trump issued executive order saying children born of people illegally and temporarily present here are not subject to the jurisdiction thereof, and thus do not qualify for citizenship under the 14th Amendment. They're referencing the federal act and federal law uses the same language. So some illegal aliens who want their kids to be here and be citizens sued, some on their own behalf, others on the behalf of their children. They say this violates the 14th Amendment. District Court said, you're right, illegal aliens win. It provisionally certified a class of children who would be denied citizenship and said Trump's order is paused. So here they're going to explain to us about how the citizenship clause works, even though they can't quote it legitimately. We have to understand Dred Scott. Now, the story of citizenship, writes John Roberts, begins with English common law. Okay. Before the Revolution, colonists, like all in the British Empire, were considered subjects of the sovereign. That arose not from royal fiat, but from what we described as a relationship between the sovereign and the people. The king said that if you're born within the dominion, then you are subject to protection. Born within the dominion in return for protection means you owe the king a duty of allegiance. And because the sovereign's power and thus his duty was limited in various respects, so too was the scope of this rule. He could not demand allegiance from, for he could not protect, those born in lands that he did not control. In all other respects, however, the sovereign's power and his claim to the people's allegiance was complete. A foreign mother could enter the British Isles, give birth, and leave with her child the very next day, and that child would remain a British subject. Why? Not anymore. Now they don't do that. In Europe, they say, no, you got to have a parental that has a blood connection to the nation, because the child owed an implied allegiance to the sovereign who protected him at his birth. So the same rule applied to children who were born into parents subject to expulsion, like gypsies and others. This view crossed the Atlantic with the colonists and was adopted with little fanfare after the Revolution. As subjects of the sovereign become citizens of the states. This common law of citizenship is known as jus soli, the right of the soil. If you're born geographically, it's jus soli versus jus sanguinis, which means by blood. So it's by land, by soil, and by blood. That prevailed in each of all of the states after the independence. And by the doctrine of natural allegiance, all who were born within the jurisdiction were citizens within the jurisdiction of a state. Robert says, when the newly independent Americans confronted a novel situation unknown to England, that of the quasi-sovereign Indian tribes, they turned to the principle of common law. Did the tribes truly govern their people, or were their people wholly subsumed within the United States? They look back again at common law. We have purchased the greater parts of their lands, destroyed their hunting grounds, and abridged their native independence. But we've never dealt with those people within our national limits as if they were extinguished sovereignties. So they were instead dependent nations that maintained dominions of their own. Indians born under those circumstances were not citizens or subjects of the United States, but members of alien and sovereign tribes. Others followed his interpretation. Now, in a nation of immigrants, he quotes, legal, lawful immigrants, legal, lawful, an asylum for mankind, in Thomas Paine's word, jus soli, which is by soil, the broad scope took on particular importance. The young republic attracted tens of thousands of immigrants from various places. Some just hoped to live and stay for a short time. Others who never wanted to leave. Now, no matter their intentions, their kids would be citizens. The very first American legal treatise agreed, and it said the common law was that children of citizens and foreigners, including those merely here on a temporary sojourn, were citizens, which is like the anchor babies from China now. The promise of American citizenship extends to all persons born within the jurisdiction of the United States, is what they wrote back then. And that's different than subject to the jurisdiction. So he says the common law made no distinction on account of race or color, but the slave states did. As the Civil War approached, more and more of the southern states sought to deny citizenship to Black Americans and openly rejected the common law. They said it was not the place of a man's birth that made him a citizen. These states said, but the rights and privileges that he may be entitled to enjoy. Not even emancipation could confer citizenship. And with the common law abandoned, 500,000 free Black Americans in the South were left little more than strangers. And so in the odious decision of Dred Scott versus Sanford, the court imposed the Southern states' beliefs on the nations, writing that they concluded the words people of the United States and citizens had a racial component, one that excluded all those who descended from slaves. Dred Scott was met with shock, and ever since the Declaration of Independence, the received general doctrine has been, in conformity with the common law, that all free persons born within the state are citizens. Newspaper condemned it. Abolitionists swore to undo what the court had done. And so the court eventually had overruled the common law, but the people eventually would overrule the court. The Reconstruction Congress did not start from scratch, writes John Roberts in A Betrayal of America, saying, in the midst of the Civil War, President Lincoln's Attorney General issued a landmark opinion that wanted to displace Dred Scott, saying every person born in the country is at the moment of birth prima facie a citizen, without any reference to race, color, or accidental circumstances. Meaning, it's on its face. And a year after Lee's surrender at Appomattox in the Civil War, Congress wanted to turn that into law. The result was the Civil Rights Act of 1866. In that act, it said all persons born in the United States, and look right here again, and not subject to any foreign power, not subject to any foreign power. That's the predecessor to the 14th Amendment. They just gloss over it. Excluding Indians not taxed or hereby citizens of the United States. This is what turned into the subject to the jurisdiction thereof clause. And this is the predecessor, which means if you're an illegal alien, you are subject to a foreign power. You're subject to Guatemala or Mexico or wherever you're coming from. To the Reconstruction Congress, the act was simply assumed to invoke the common law rule. And he cites some debate here. Indeed, the bill's sponsor, Lyman Trumbull, enthusiastically agreed with the bill's critics that it would make citizens of the children of Chinese and Gypsies born in this country, even if the infant child of a foreigner born in this land is a citizen under this bill. Now, the specter of Dred Scott, however, loomed over Congress's efforts. Opponents of the act contend that Congress could not grant this expansive citizenship by statute alone. And to quiet all of that, Congress came up with the 14th Amendment. Now, what the Civil Rights Act began, the 14th Amendment would finish. Like the act, the 14th Amendment was intended to repudiate Dred Scott. This time, the goal was even grander. And it achieved its aim. The Citizenship Clause mirrored the common law's criteria, saying a child must be born in the U.S., not elsewhere. And the clause ends, again, like the common law, with the sovereign power, a child must be subject to the jurisdiction, which is unlike families of foreign ministers. A child born on American soil and subject to American law was made an American citizen. So it's just geographic. You happen to be here. Even the language of the clause is that of the common law. Lynch said that an American citizen and citizenship extended to all persons born within the jurisdiction. So did others. So did the first legal treatise. And by the way, freed slaves, freed Black Americans, as in the Civil Rights Act, they were not subject to a foreign power. That's the point. They were not subject to any foreign power because they were in America and they were brought here against their will and made to be slaves. So they were not subject to some African country. That is what the rule should have been interpreted to mean. So even putting the common law to one side, the Citizenship Clause And the key phrase, subject to the jurisdiction, which they can't even put a comma in front of, requires the same result. The word jurisdiction was hardly unknown to the drafters. In 1868, as today, it means power of governing or legislating. Yet we know what that word means. It is subject to. To be subject to, then, is to live under its dominion. To be subject to that, and they say that is a meaning reinforced by the clause's territorial focus on those that are born in the United States. And so it uses jurisdiction in the ordinary sense, not meaning some type of allegiance. The scope of that power was well settled in 1868. Judge Marshall, the guy who gave them the power of judicial review, also not in the Constitution, explained that jurisdiction referred to the full and complete power of a nation within its territories. And that's the same jurisdiction that illegal aliens, when they come in, are violating. They're saying, you have no complete power over me. That's why I'm coming in illegally. All sovereigns, however, were understood to have impliedly waived their jurisdiction when jurisdiction would degrade the dignity of foreign sovereigns. And so in the context of jus soli, which is birth on soil, those particular circumstances were invoked when it related to foreign ministers. And so the limits of that exception are all carefully defined. Still within the United States' power were the private individuals of a foreign nations who spread themselves out. And it would be inconvenient to society if these individuals were not amenable to the jurisdiction of the country. And so just like birth by soil, a sovereign's jurisdiction made no exception for those only temporarily present here within the territory. Instead, nearly everyone within the boundaries was amenable to the nation's jurisdiction. And so the ordinary legal meaning of the text of the clause thus neatly captures the rule with its broad reach and narrow exception. The same groups included and excluded by birth by soil were included and excluded by jurisdiction, the word. Excluded by both were the children of foreign ministers and members of the 19th century Indian tribes, over whom the United States had ceded a part of its jurisdiction to preserve its relationship with the quasi-sovereign. No such inner sovereign concerns apply to children born of parents unlawfully or temporarily present, so they count. No foreign sovereign would have any motive for wishing them outside this nation's authority. Those children then are subject to the jurisdiction of the United States. They satisfy both elements of the clause. They are born in the United States and they are subject to the jurisdiction thereof. Under the Constitution, Roberts and Amy, with the worst decision ever, are citizens at birth. Illegal alien invaders come in and they get the benefit of breaking the law. They can just drop their babies off. Don't even have to come in illegally. Just come in as a Chinese national who wants to have a baby here. And so they go through Wong Kim Ark, which we've talked a lot about here. And Wong Kim Ark, in this case, the parents were here legally. For nearly 2 decades after the 14th Amendment, the executive branch viewed the citizenship clause as simply an affirmance of common law, which means citizenship fixed by place of birth. That's it. Doesn't matter where your parents came from or how they came here or whatever. As long as they plop a baby, you're good. One case was about Austrian parents that he says counted. And as the era of Reconstruction faded, so too did the promise of birthright citizenship. Uncertainty came with the Chinese Exclusion Act. It was around this time the State Department began to deny citizenship to those with dual or doubtful allegiance. And it was around that time that several scholars proposed a new theory of the clause based on international law. No other modern nation does this nonsense anymore. This new theory focused on the parent status, not the child. If the parents of the child were domiciled in the United States, legally living here, then the child was internationally subject to the jurisdiction thereof. The writers acknowledged it was a different view, but they insisted that jus soli, which is the geographic birth by soil, has been universally rejected. Then in Wong Kim Ark, this court rejected that view, not really, concluding that no rule of international law had qualified the ancient rule of citizenship by birth within the Dominion. This case, Wong Kim Ark, we've talked about it a lot here. This kid, Wong Kim Ark, was born in San Francisco to Chinese parents. And in Wong's telling, the case was not close. There can be no doubt that the amendment was intended to be based upon the doctrine derived from the common law, that the character of a natural-born citizen is incidental to birth only. Government disagreed, admitted a bunch of arguments, and then Justice Gray rejected the government's position. He explained the 14th Amendment was merely declaratory of the fundamental rule of citizenship by birth, saying the same rule was enforced in all the English colonies and continued to prevail. It excluded those recognized as exempt from the jurisdiction of this country, which included the children of ambassadors and other representatives of foreign sovereigns, as well as Indians. All others were citizens at birth, whether born to permanent residents or temporary visitors. Justice Gray noted that no one had even contested this conclusion for more than 50 years after the adoption of the Constitution. And there the question was decided upon full consideration by the Vice Chancellor. He then turned to other prior cases. Wong Kim Ark is a massive case. And what they held in that case was simple. The Citizenship Clause incorporated the common law view that granted citizenship to nearly all children born in the U.S. Not surprisingly then, the 128 years since, we've repeatedly understood Wong Kim Ark, whose parents were here legally, not illegally, to guarantee citizenship to everybody who plops out here today. So we see no reason to depart from that view. And the dissent share many of our premises. And where they err, though, is about their definition of allegiance. And so just like yesterday, Robert spent a huge amount of time yesterday during those decisions trying to distinguish from Thomas. Like half of his opinion was trying to rebut Thomas. They say natural allegiance was no longer sufficient for citizenship. Some greater quantum of allegiance was required, but how much? Many different formulations. Is it primary allegiance? Is it sufficient allegiance? Is it full allegiance? Is it requisite allegiance? He says with all this formation, then they turn on domicile. Now, at some point, the ratification of the 14th Amendment, the argument goes, it became deeply rooted in this country that domicile is the concept that creates allegiance. We're not even at domicile. The 14th Amendment, as we saw, also has this phrase in here that is called residency, wherein they reside. You see that word right there after they miss the comma? Apparently they're forgetting about the word reside. We'll see if they get there. Residency doesn't mean temporary, okay? It means you actually live there. It means you're not from China coming in and plopping babies off. The trouble is that there is scant evidence for this dramatically revisionist view. Certainly no one said that a change had occurred. And even as the antebellum Americans hotly debated the Declaration of Independence and questions about natural allegiance, that was indefensible. The only evidence the government and the principal dissent can muster to show that some alternative primary conception of allegiance displaced the common law after, they wrote the entire amendment to incorporate the new position was the funeral oration of President Abraham Lincoln. But otherwise, they identify no source in the dissent that defined allegiance at birth as being based on domicile in the period from 1776 to 1868. Sources from that period, well, are you skipping over the 14th Amendment? Maybe the 14th Amendment then rewrote that by amendment to the Constitution. So, of course, some wish to just change the rule, but even those who wish to limit birth by soil did not deny that children born of temporary visitors owed natural allegiance to the United States. How? How does a Chinese baby plopped off here and have my baby in Miami have any natural allegiance to us? They instead thought that domicile meant that would be a reasonable qualification to the common law rule, saying natural allegiance owed to the government of a territory of a man's birth. So he's spending time on the dissent. We'll go into the dissent at length. Of course, domicile was relevant to naturalization and expatriation, but that by no means says that the prerequisite is that as to a natural citizenship. The principal dissent's reliance on cases concerning changes to a person's state citizenship is thus misplaced. And the government's remaining support for the idea that domicile is a qualification to birthright citizenship was widely accepted in the U.S. before the Civil War consists of a single state court case about citizenship in the Republic of Texas. And that's not good enough for us. And the debates over the Civil Rights Act also confirm our view. The principal dissent leaned heavily on a handful of ambiguous floor statements about temporary sojourners and foreigners. And that was just part of the debate. Far more frequent and explicit were statements embracing common law. And so our view in the legislative history wins out. For a Congress intent on putting a question of citizenship to rest, a domicile-based qualification would have introduced significant uncertainty. Unlike the easy-to-apply common law, it would be difficult, if not impossible, to lay down any general rule of domicile-based citizenship, as domicile often depends on circumstances of each case. If Congress intended to hinge citizenship on each domicile, it's reasonable to expect that they would have talked about it. And perhaps recognizing the absence of this support for domicile, the government and dissent both emphasize sources after the ratification of the 14th. They look at other things that we don't think have any weight. As Trumbull explained in 1871, the Citizenship Clause recognized that every person born within the jurisdiction was a citizen, and that was true forever. So in any case, post-enactment history cannot override the law. If Congress intended to limit American citizenship to the children of those domiciled in the U.S., nothing in the succinct language of the clause conveyed that design. Words appearing frequently in the executive order, mother, father, lawful, temporary, are not in there, and for a simple reason, they did not matter. And while the clause does ensure that state citizenship attaches for U.S. citizens in the state wherein they reside, there we go, the explicit invocation for state citizenship only highlights its absence for U.S. citizenship. And so the principal dissent is going to explain a lot more of his arguments here. They spend a lot of their time on the Civil Rights Act, so he's rebutting this. And their theories don't work, says Roberts. As to the principal dissent, it is simply not true that domicile in a new nation severs one's ties to the old nation. If the test truly is whether a person is amenable to the laws of the government, then it is a test that every child born to a foreign parent fails. And Alito seems to recognize this bind, which means he creates an exception to this. He does not explain how that exception can be squared with his view of the text, which is to repeat that anyone automatically made a national in the native country was not entitled to citizenship under the Civil Rights Act because they were actually subject to a foreign power. So they say the act actually raises more questions than it answers, and the 14th Amendment gave the better rule. And so for the dissents in the government, Wong Kim Ark is essentially irrelevant. They attempt to narrow that precedent because of the domicile. That is true. The parents were there legally, and the holding of Wong Kim Ark cannot be squared with the domicile requirement in other cases. It is an unbroken line from English up to our clause, and they don't have any better evidence to refute that. And so again and again, the dissent cast the common law as feudal, medieval, and a remnant of the darkness of the Middle Ages. But that is not the view of the Reconstruction of Congress. When the dissent sees feudalism, the framers saw emancipation. For people who were lawfully here, for the slaves were being emancipated. We're not emancipating the whole friggin' planet who comes in and breaks the law. By the time of the Glorious Revolution in 1688, the tie created by birth was less a duty than a right. That's why Blackstone described privileges. And so citizenship, then and now, was the right to have and to freely participate in our political community. The framers of the 14th Amendment extended that promise to every free-born person in this land. We keep that promise today. Wow. Wow. So heroic, John. The judgment of the District Court of New Hampshire is affirmed. So it is a constitutional holding. It is that the 14th Amendment, which can only be modified by another amendment, or by a reversal of this horrific case, which is not going to happen in our lifetime, by the way. It'll probably never happen ever, because the country has already been invaded by 20 on the low end to 100 million foreigners. So there's never going to be the political will to amend it or to reverse this. Sorry to be so black pilled, but it's true. So here's what the leftists say. They say Jackson and Sotomayor in a concurrence. And we want a colorblind constitution. Justice Thomas is making it a race-conscious remedial measure, but we want a colorblind constitution. And Ketanji is going to just spend a lot of time. We're going to fast forward through her. She's in the majority. It's all about racism and slavery and colorblind constitution. So we're going to fast forward through Ketanji. Let's get into the dissents, which I think have the better argument, but not today, because Amy Coney Barrett and John Roberts join with the lefters. And here we go. Kavanaugh, let's see what he says. So as we see, just to be ultra clear about this, in our breakdown, we've got the three leftists. It is constitutional. Can't change it. It's codified already. You need another amendment to reverse it. This is the worst possible outcome of all four options. We've got Roberts and Amy Coney Barrett joining in that. Question is, where does Kavanaugh sit? What is his basis for the holding? Not that it matters all that much, because he's concurring in judgment and he's dissenting in part. He says, the court holds today that the order violates the 14th Amendment. I respectfully disagree with the constitutional holding. In my view, it doesn't violate the 14th, but it does violate the statute. Okay, so at least Kavanaugh is in this box. At least. And either Amy or Roberts could have joined this holding and been over here, this logic, saying it's not a constitutional issue, it's a statutory issue. So at least Kavanaugh says that. Congress could, consistent with the 14th Amendment, change it, enact new legislation establishing exceptions for foreign invaders, but they haven't done that yet. So I consider the statutory arguments, the law under U.S. Code, Title 8 says what we read earlier. Wong Kim Ark, that case, writes Kavanaugh, interpreted that phrase. The decision adopted a general rule of birthright for those born with 4 exceptions, and Wong Kim Ark treated those 4 exceptions as a closed set. Then in 1940 and 52, Congress employed the exact language from the 14th Amendment in their laws. Because that uses the same language as the 14th Amendment, we've been interpreting it as though it interpreted the constitutional amendment and not the law. Importantly, from the time of those enactments in the 40s and 50s, the executive branch consistently interpreted the statute passed by Congress to encompass the exceptions under Wong Kim Ark. Then Trump came out and he sought to add 2 new exceptions, but he can't do that. Only Congress can do that, and it's a separation of powers argument. Now he says, I want to talk about the 14th. As revealed by the court's opinion in its detailed account, the issue is far more complicated. The constitutional issue is far more complicated. And after reading those opinions, one thing is evident. The issue is not straightforward as much as we might want it to be. Yeah, so Roberts is he's finding an outcome that he wants and then backfilling it. This is another reason why, in my respectful view, the court should have decided the case on the narrow and straightforward statutory ground, which is here. They should have been in this box, but they didn't. They totally freaking screwed us. So ratified in 1868, the Citizenship Clause of the 14th Amendment. Oh, look who got the comma right. There it is. Wow. All persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and of the state wherein they reside. So Kavanaugh got the comma right, and he had a better holding. Maybe if Amy Coney Barrett and John Roberts knew how to punctuate, then things would be better for us. In 1898, Wong Kim Ark interpreted the 14th Amendment, subject to the jurisdiction thereof, to be the general right of birthright citizenship, except for certain exceptions. But Wong Kim Ark treatment of this issue as a closed set is incorrect. And the Constitution is an enduring document. And so it needs to be faithfully applied. In the Fourth Amendment cases, courts can apply reasonableness requirements. And so ordinarily, the relevant rule and the exceptions apply to new circumstances. And in oral argument in this case, many members of the court explored that critical interpretive point at some length. The citizenship clause of the 14th should be no different. The 1898 decision recognized 4 exceptions under the basic tenets of constitutional interpretation. Other exceptions can be recognized. We write exceptions into the Fourth Amendment all the time. We can do the same thing here. It's standard operating procedure. And here, that interpretive principle would support additional exceptions for foreign invaders. First, significant illegal immigration is new. That was largely unknown in 1868. John Roberts is screaming about emancipation in 2026. And the framers likely would not have anticipated that our own government would betray the entire nation by allowing the country to be invaded. And now, you think the framers would have intended the odd result of granting substantial birthright citizenship benefits to foreign citizens who actually violate immigration law and overstay illegally in the country, or those who follow U.S. law and have children in their home countries who then want to lawfully immigrate? You get a benefit by breaking the law, says Kavanaugh. Nor presumably would the crafters of this law, would they have wanted to grant constitutional birthright citizenship to children of foreign citizens unlawfully in the country while then denying it to children of tribal American Indians, which is what they did. So the issue of temporary visitors who give birth presents a new and different circumstance, and we should have not made it constitutional. And second, those two categories of foreign citizens, namely those unlawfully or temporarily in the country, are relevantly similar to the 4 categories of persons recognized in Wong Kim Ark. And so all of that said, as noted, in 1940 and 52 at the time, we recognized exceptions and codified that by Congress in the U.S. Code. And so for those reasons, the executive order does not violate the 14th Amendment. I could live with that holding, but the order does violate the statute, because then Congress could come back out and just change this. We're not going to be able to change the 14th Amendment. I mean, you can hold out hope that maybe the American populace wakes up and says, we don't want this to happen anymore. But you have to understand that the invasion that brought in 20 to 100 million people, they're going to have citizenship kids. And 1 or 2 generations out, they're going to be in alignment with this rule. So they're not going to want to amend. They're not going to want to change anything. And it's going to get worse, not better. This was the moment. Consistent with the 14th Amendment, Congress could simply amend that and enact new legislation establishing exceptions to birthright citizenship if you're born here unlawfully or temporarily, like the anchor babies that fly in and get dropped off. But Congress has not yet done so. And so Kavanaugh is in the majority, but he would hold it as a congressional issue, not a constitutional issue. So this is where we're at right now. And it's not good, man. Not good. All right, let's see what the dissent says, because these should be fire. Clarence Thomas, with whom Justice Gorsuch joins. He says this court's decision in Dred Scott would have permanently denied citizenship to blacks as a subordinate and inferior class in 1857. Now, after the Civil War, the Reconstruction Congress overruled Dred Scott. They did it first with the Civil Rights Act of 1866, then again with the Citizenship Clause of the 14th Amendment. Both the Civil Rights Act and the Citizenship Clause guaranteed citizenship to persons born and domiciled in the U.S. regardless of their race. Neither, though, guaranteed citizenship to persons who were not domiciled in the United States. Clarence Thomas says, Blacks were entitled to citizenship because they were Americans. They had no other homeland. They owed no allegiance to any foreign power, and they were subject to no other authority. They fought and bled in the same battles. They were gained and gloried in the same victories, and they were liable to be called upon to defend America in a time of war, alongside every other citizen. They were Americans. These people who are coming in illegally are not. They haven't done any of this crap. They haven't fought and bled. They weren't brought here against their will. They didn't violate the law. They did violate the law, but the African Americans did not. They were brought here against their will. The people coming from Guatemala are not brought here against their will. They come in here on their own volition in violation of our laws. To compare them both to one another, like John Roberts and Amy Coney Barrett did, is to diminish the plight of the slaves and the history of Black Americans in America. To make a false equivalency between foreign invaders and the people in America. The Citizenship Clause thus guaranteed them the dignity and the glory of American citizenship, so as to ensure that they would never be treated again as second-class citizens. Now, the same could not be said for the children of foreign temporary visitors. It's not the same bucket. Foreign temporary visitors were attached to their home country. They lacked similar bonds to this country. They would not be called upon in a time of war. Americans, consistent with the settler ethos, believed that citizens were the people who called a place home. And so accordingly, domicile, a person's legal home, played a key role in both state and federal citizenship. A person was a citizenship in a state where they had domicile. We decided that in 1859. When foreigners temporarily visited, their national character was unchanged. They're here temporarily. Such visitors were strangers. They weren't subjects. And so a person born here, but domiciled, living in a foreign land, was therefore considered as much a stranger to the country as was his father. So that is why when Dred Scott went to court, he argued that to be a citizen, it is only necessary that he should have domicile. After this court said that Scott was not a citizen simply because he was Black, Republicans in Congress, such as Representative John Bingham and others, stated that a person was a citizen if he was born and domiciled here. Scott was a citizen in their view, Dred Scott, because he was born to Americans, not temporary sojourners. And as Frederick Douglass had put it, the freedmen sought citizenship not as aliens nor as exiles, but as Americans. Congress implemented the principle that citizenship follows birth and domicile when they passed the Civil Rights Act of 1866. Then again, in the Citizenship Clause in the 14th Amendment, the Civil Rights Act guaranteed citizenship to persons who were born in the United States and, as relevant here, not subject to any foreign power, meaning they are stateless. They don't have another country that calls them a citizen. The phrase "not subject to any foreign power," writes Clarence Thomas in his Dissent, excluded from citizenship children of foreign-born temporary visitors. They were subject to the power of their home country. So your baby belongs to them. The Citizenship Clause, which the same Congress passed shortly thereafter the Civil Rights Act, was understood to have the same meaning. It guaranteed citizenship to persons who were born in the United States and subject to the jurisdiction thereof. Very simple. A person was subject to the jurisdiction of the government of his domicile. Domicile was the foundation of jurisdictions over persons. According to another treatise, The Law of Nations, that John Roberts apparently didn't read, the government of a person's domicile has broad powers over that person, including with respect to his personal affairs, his conduct abroad, his personal taxes, mutual duties of protection and allegiance. So as the senator who introduced the Citizenship Clause explained during the debates, the word, quote, jurisdiction, he said, as here employed, ought to be construed so as to imply full and complete jurisdiction, okay? The same jurisdiction in extent and quality as applies to every citizen of the United States now. After all, Congress would have no right to make citizens of persons who are here temporarily residing. Senator Trumbull said that too. But John Roberts and Amy Coney Barrett liked his other statements, so they picked those and weighed those against that statement. They're both citing the same person. The citizenship clause was consistently interpreted not to apply to the children of foreign temporary visitors, who were by definition not domiciled here. Regardless of the administration or the party, the government for decades after ratification regularly denied claims to citizenship by children who were born in the U.S. but not living here, not domiciled here. When a child was born in the United States, the parents domiciled living abroad, he was not, therefore, under the Constitution, a citizen. Scholars agreed. A child born within the territory of the U.S. of alien parents was not a citizen unless his parents were again permanently domiciled here. The court agreed. The citizenship clause excluded from its operation children of the citizens or subjects of foreign states born within the U.S., and Congress agreed too. The citizenship clause did not extend to a child born here, but subject to any foreign power. You are subject to them. That's yours. That's your nation. This is ours. Justice Harlan wrote in his dissent in Plessy versus Ferguson that the citizenship clause gave citizenship to all born or naturalized here and residing here. But now the court offers a different account, says Clarence Thomas. American citizenship, the court says, is based on a medieval English feudal principle, according to which each person owed a personal service to the lord of the soil and as his master. In other words, a perpetual servitude that was born with the child and only ended in the grave. And then as Americans, the court says, we adopted that feudal principle as a rule of our American citizenship with little fanfare. Oh, I guess we're all sovereign because we're here. We owe an allegiance to the nation. We're not free people. The fact that you're just born here means you're allegiant, like the king, like slaves. So then, according to the court, the Reconstruction Congress codified the feudal principle with the words, not subject to any foreign power in the Civil Rights Act and subject to the jurisdiction thereof as well. Then Roberts and Amy, they say the clause's meaning was definitively settled in dicta. In other words, dicta, which is speech language included in the decision that's not even relevant to the holding in Wong Kim Ark. Clarence says, with due respect, the court's account is not historically accurate. The court says that the citizenship clause incorporated the English feudal principle that subjects owed lifetime servitude to the king, literally based on the soil, but Americans rejected that. We did that unsurprisingly. The court's theory now of American citizenship is based on the opinion of a New York assistant vice chancellor in an inheritance dispute back in a case called Lynch versus Clark. But the assistant vice chancellor's reasoning, whatever it was worth, was not even followed in New York at the time. And finally, the court then reasons that dicta in Wong Kim Ark settled the meaning of the clause. But Wong Kim Ark itself emphasized that its holding was limited to persons domiciled. And scholars and government officials continue to agree after Wong Kim Ark that the citizenship clause did not extend to children of foreign temporary visitors. The rule remained what it always was. A child born on American soil of a stranger or a traveler passing through the country or temporarily residing here was not a citizen. So the court today takes the extraordinary step of holding facially unconstitutional the president's order, excluding from citizenship the children of foreign temporary visitors and illegal aliens. In doing so, the court adds to the sad history of the 14th Amendment, which was designed and understood to secure equal rights for the freed blacks, but has instead been repurposed for political projects that the Reconstruction Congress did not support. Because many potential applications of the president's order are consistent with the original public meaning of the citizenship clause, I respectfully dissent. From Clarence Thomas, continuing. Now, I begin with early American practices related to citizenship and nationality, which inform what the clause means. In America, you were generally a citizen if you were born here and this was your home. The legal word for home was domicile. The concepts were so linked as to be taken effectively synonymous at times. Citizenship means domicile. Domicile means home. That means permanent residence. The same correspondence has persisted throughout American history. In fact, citizens were not the only people who were temporarily passing through a territory or who happened to be born in it. Citizens were the permanent members of the body politique, the people whose roots were in place, who called that place home, and who would, if necessary, go to war for that place. The law of both state and national citizenship reflected this important principle. Now, domicile was critical for state citizenship as well. Marshall explained that a person who was a citizen of that state means he has a fixed and permanent domicile. And temporary visitors, therefore, were not citizens. When a person went to a new state on a temporary visit for a transient purpose, he's not a citizen there. Instead, to become a citizen of the state to which he removes, he's got to prove domicile. It's literally the same rule today. An individual is deemed a citizen of the state where he resides, where his domicile is. Also critical is this concept for national citizenship. As this court has ruled, when a person acquires domicile in a nation, he becomes a member of the new society, at least as a permanent inhabitant. And domicile played a role in determining someone's national character, which would change whenever he moves or goes to a foreign land. Thus, the view of the executive branch was that when a person acquires an American domicile, the law enjoins upon other nations to respect him in regard to protection as an American citizen. He's one of ours. He lives here. Domicile confers a national character. It does not allow anyone who has a domicile to decline the national character thus conferred, citing cases. His status remains as long as the domicile is retained and changes with it. So this approach is consistent with this country's settler ethos. Daniel Webster wrote that no government has carried the general presumption further than the U.S. that the nation a person attains a new national character when he settles in it. Although some nations would lay claim to anyone born in their land, America viewed their people as the people who built their lives here. A person domiciled pays the same price for his protection as a native born or natural citizen pays for theirs. In war, he shares equally. In calamities, he shares equally. His life may be periled or sacrificed in maintaining and vindicating his honor, all connected to domicile. And so the U.S. thus did not claim as a citizen every child born on its soil. Instead, pursuant to the principle that children followed their parents' domicile, a child was a citizen of the place where his parents were domiciled. A child born of foreign parents is not, on principles of natural reason, that's too hard for Amy, necessarily to be considered a citizen of the country where he is born. If he was born in the country, but both his parents were strangers, not designing a permanent change of country, then he's as much a stranger, the baby, as the parents. The rule was that when a subject is traveling or sojourning abroad, he continues under the protection of his home nation. So his children are an exception to the rule. And the relationship between citizenship and domicile was, as a matter of general law, from which the political branches could depart by statute. And those statutes also typically track domicile. So Congress retained the prerogative to set the terms for becoming a naturalized citizen and could impose requirements beyond domicile. But then when Congress enacted naturalization statutes, they too generally track domicile. For example, this one, requiring 5 years of residence for naturalization. And in this case, requiring 2 years of residence for naturalization. And even when a person was domiciled here and not formally naturalized, he was already considered a citizen for the same purposes. Before being naturalized, domiciliaries were de facto, though not de jure, citizens of their country of domicile. And likewise, for other purposes, national citizenship was not an independent concept, but it was a derivative of state citizenship. Every citizen of a state, it was often said, was ipso facto a citizen of the U.S. And so in these contexts, national citizenship required domicile because state citizenship required domicile. And of course, birthplace is closely correlated with domicile. Most children were born where their parents were domiciled, and as a result, they were there too. This correlation is especially strong today, as it was in the 19th century. when crossing an ocean for a temporary visit was an unappealing prospect for pregnant women. Because birthplace was often a heuristic for domicile, it could be generally stated that children were citizens of their place of birth. But when that specific question arose, a reasonable qualification to what general statement accepted children of parents who were in itinerary in the country or abiding for temporary purposes comes into play. And so Clarence Thomas in his dissent says, domicile is essential to understanding the citizenship provisions of the Civil Rights Act and what came after the 14th Amendment. So I want to explain that here. Domicile meant legal home. It means domicile, a place of residence with intent to permanently remain. And that's where he lived. A person was not domiciled in a place simply because they flew to have my baby in Miami. A person's presence in place was merely prima facie evidence that he was domiciled there. And because a person's temporary visit to a place did not change his domicile, persons who were temporarily present in a place were not subjects, they were strangers. A child took on the domicile of his parents because any person incapable of establishing his own domicile had that he inherited. And finally, each person had one and only one domicile. You live in one spot, pick one. So if someone did not intend to remain where he was at the moment, the law ascribed that person his last such place as domicile. Now, because a person could have only one domicile, domicile was a natural criterion for citizenship. In the 19th century, dual citizenship was considered highly undesirable, if not a contradiction. It is a contradiction still today. It is a double allegiance, which is why we have such a big problem with it and federal judges having it. Because each person had one and only one domicile, domicile-based citizenship avoided the problems attendant to dual citizenship. Now, the principle that citizenship followed domicile, writes Clarence Thomas, also made it more likely that citizens would be attached to their country. Hamilton envisioned it accordingly. We want a citizenry where people would join together against any threat. We want a large body of citizens who stand ready to protect their country, not a bunch of foreigners who are protesting around, literally waving their foreign flags all over the place because they don't give a crap about America. They think it's just an economic zone. They think it's stolen land. They don't even want America to exist. And Roberts and Coney Barrett just facilitated the destruction, saying there is a glory of American citizenship that is dignity, not just coming here and getting free healthcare, free housing, free food, and so on and so forth, siphoning off the actual citizens. A domiciliary had, by definition, the sort of permanent attachment to a place that befitted him for citizenship, and somebody who is temporary did not. So once a person became domiciled, then he was considered no longer a subject of any foreign power because you live here. Court explained this in prior cases, and legal authorities also described this as well. Subject to the jurisdiction thereof means domicile. Then, as now, the government exercised different types of authority over temporary visitors and permanent residents. One counts, one doesn't. In contrast, when a party made his habitual and usual domicile in a place, then he was subject to the jurisdiction thereof. More on domicile, but then we get legal relationships that follow domicile. First, domicile determined which government had the power to declare laws as they relate to the person. In your domicile, you follow marriage and divorce rules. It also governed the succession of a person's estate. It governed the age of majority, the capacity to contract, your right to sue. It anchors you into the jurisdiction. And domicile also determined, says Clarence Thomas, which government had plenary jurisdiction over that person and what state, what location, what government can exercise their authority. And it also dictated which person and which sovereign has the ability to impose taxes, property taxes, capitation taxes, and more. All of it is being collected from actual domiciled people. And fourth, domicile also determined which government owed a personal protection to that person when he went abroad. This court explaining the same. A non-naturalized domiciliary abroad was entitled to protection as an American citizen, citing cases. This protection abroad corresponded to the primary allegiance that the domiciliary owed to his home government, saying that his state still possessed a right of his allegiance. This is way more detailed than anything Roberts and Amy Coney Barrett crapped out today. They were talking about English law and how geography makes a connection to the sovereign, makes a connection to the government. Clarence Thomas just articulated for us each nexus of that connection. 4 of them right now: contract law, protection law, taxation. It's creating a body politique. It's creating a group of citizens, which was codified under the 14th Amendment, as he'll get to. So back to the Dred Scott case, Clarence says, when Dred Scott sued for his freedom, he claimed to be a citizen of Missouri because he was domiciled there. Scott, a black man who was held in slavery, sued in federal court, which could only hear the case of citizens. He said, I am a citizen. Although he was not born in Mississippi, he was born in Virginia, he lived in Missouri. And he alleged that he was a Missouri citizen because they were brought there and they were domiciled there, they resided there. He said citizenship defined a person identified with the communities where they reside. So in response to the argument that blacks could not vote and therefore were not citizens, Scott explained that a person need not have acquired all these rights. It is only necessary that he should have acquired domicile to enable him to sue as a citizen. Nobody agreed with that premise that Scott was domiciled in Missouri. Black slaves and freedmen alike were unambiguously Americans. They were not foreigners. They were not aliens. They owed no allegiance to a foreign allegiance, to a foreign nation. It was the dissimilarity of American blacks to foreigners that Frederick Douglass emphasized in his call for recognizing the citizenship of blacks. And Amy Coney Barrett and John Roberts are dumping all over this history. They're equating the black plight in America and all of the history with people from Guatemala who just want to race across the border. They are not the same. And it's offensive. We address you not as aliens nor exiles. We humbly asking to be permitted to dwell among you in peace. Instead, we are Americans. So speaking the same language and being of the same religion, worshiping the same God, owing our redemption to the same Savior, and learning our duties from the same Bible, said Frederick Douglass, we shall not be treated as barbarians. Clarence says American blacks were liable to perform all the duties and support all of the obligations of citizens. They were domiciled here, whether in slavery or freedom. And so Dred Scott was a citizen of Missouri. But this Supreme Court disagreed with that. It said Scott was not a citizen and therefore could not sue because he was black. According to the court, blacks could not be citizens because they were considered to be a subordinate and inferior class who had been subjected by the dominant race and, whether emancipated or not, remained subject to their authority and had no rights or privileges at all. So as a result, the court said blacks were denied the basic privileges of citizenship and they could not sue. Now, there were dissents in that case. McLean and Curtis said he actually is a citizen. He lives there. He's domiciled there. Birthplace alone is not sufficient to become a citizen because they must both be born here and be a citizen. But they agreed he was a citizen of Missouri. And domicile, after all, was colorblind. In the words of John Bingham of Ohio, soon to become a central figure in the 14th Amendment, a quote from the Congressional Globe: all persons born and domiciled within the jurisdiction are citizens from birth. Blacks like Dred Scott called America home, so they were citizens despite having been subordinated based on race. Another representative explained, persons of African descent whose ancestors were slaves were entitled to citizenship because they were domiciled and continued to reside there. And it applied because they were not temporary sojourners. Now, chief among the critics of Dred Scott was Abraham Lincoln. Soon after the court released the decision, Lincoln said this case is erroneous and did obvious violence to the plain, unmistakable language of the Declaration of Independence. The case exacerbated national division over slavery, and Lincoln got elected. He vowed not to acquiesce to this as precedent, but said, we will do what we can to have it overruled. During the Civil War, Union officials continued to define citizenship based on birth and domicile. And even Lincoln's lawyer wrote that the place of birth was prima facie evidence of citizenship, a rule that corresponded with domicile. The Lincoln administration deemed persons citizens if they were born and domiciled in the United States. Congress's discussion of who would then be subject to wartime conscription and other things was people who were here, fully and completely subject to the law. So for the purpose of conscription, children of foreigners born here were American citizens if they were permanently domiciled in the U.S. They could, though, avoid conscription if they were not long-term residents. Even at the memorial service for Lincoln, prominent statesmen George Bancroft and others confirmed that everyone born on American soil, with the few exceptions of travelers and transients, owes it a primary allegiance. And so after the Civil War, Congress vindicated this. They overruled Dred Scott. We got the Civil Rights Division. We got the 14th Amendment. And what it did is confirmed that former slaves were citizens, but it did not extend citizenship to foreign temporary visitors or Indians who were still within their tribes. It guaranteed citizenship under the Civil Rights Act only if you were born here and not subject to any foreign power. Cited here, all persons born in the U.S. and not subject to any foreign power, excluding Indians, not taxed, are hereby declared to be citizens. That means if you're temporary visitors living in a foreign country, you're subject to them and excluded. When the debates were clarifying on this score, Senator Trumbull introduced the citizenship provision. He stated the language excluded persons temporarily resident in the United States. Said we would have no right to even make them citizens. He had considered limiting the provision to persons owing allegiance, but he abandoned that terminology because temporary visitors owed a partial allegiance, and he wanted to make clear that the act excluded them. And when James Wilson spoke in support of the act, he also explained that every person born in the U.S. is a natural-born citizen, except it may be children born on our soil to temporary visitors. Others confirm this as well. Bingham described it, the act, as simply declaratory of pre-existing law, which he already explained was birth and domicile. You got to live here. Bingham understood the act to grant citizenship only to children of parents not owing allegiance to any foreign sovereignty. Others agreed. A rep called Thayer said it counts if you don't owe allegiance to a foreign power. Of course, temporary visitors also all owed allegiance to their home country. And so unsurprisingly, Clarence says, the public interpreted the act to guarantee citizenship to all persons born except those subject to foreign governments, which is a class that included foreign parents temporarily in the country. So the Civil Rights Act also excluded from citizenship Indians, not taxed. This provision was intended to exclude Indians in tribes, but to recognize the citizenship of Indians who had left the tribes and joined the political body. Trumbull talked about that too. And just like temporary visitors, tribal Indians were not completely subject to the jurisdiction of the United States. They were a separate category, and we didn't have the right to impose taxes on them. Their personal affairs remained subject to their own jurisdiction, and the U.S. did not interfere with what they did, so they didn't count. Now, although the Civil Rights Act overruled Dred Scott, there were still some questions whether Congress had the power to enact this or whether it might be neutered. So then Congress said, well, the only way we can get it through is if we amend it, then no courts can challenge it, which is what makes this decision today so problematic for us. The citizenship clause of the 14th Amendment constitutionalized the civil rights citizenship provision. The main object of that clause was to settle the question of freed slaves in full. Oh, look, Clarence Thomas knows how to punctuate. In full, the citizenship clause provided all persons born or naturalized in the United States, comma, and subject to the jurisdiction thereof, comma, are citizens of the United States and the states wherein they reside. He got it. John Roberts and Amy Coney Barrett and the three leftists can't figure it out. This language, all agreed, unambiguously overruled Dred Scott, but it did not change the Civil Rights Act. Howard, who proposed the clause, believed it warranted discussion, but someone else said it doesn't need any further elucidation. It's the same meaning, which means you are not subject to some foreign power. You have citizenship down in your home country. You come here to break our laws. You're not living here with lawful legal status, which means you cannot be domiciled here lawfully. You don't count. The phrase subject to the jurisdiction was familiar. It connects to domicile. Lawyers in America would have known what that meant and would have referred to it as domicile. It was on this basis that congressmen believed the clause fixed in place the Civil Rights Act, which came before it. And nobody's asking a question, what do we mean by subject to the jurisdiction thereof? Or if you do, it means not owing allegiance to anybody else. That is what it means. And there's a subset of people there who are freed black slaves. Senator Howard agreed that the citizenship clause would not, of course, include people born here who are foreigners or who are aliens. This is a quote, who belong to the families of ambassadors or foreign ministers, all quoted right here. Senator Howard. And shortly before the clause was introduced, William Fessenden, a supporter of the amendment, he said, persons may be born in the U.S. and not be citizens. Then gave an example of a person who's born here temporarily from parents just passing through. So this was a codification of the Civil Rights Act, which was heavily debated. Indians weren't included. As Trumbull saw it, they were like temporary visitors. They were subject to their tribal nation, just like the Guatemalans are subject to their nation. It cannot be said of any Indian who owes allegiance, partial allegiance, if you please, to some other government that he's subject to us. They are connected to their sovereign. He concluded it is only those persons who come completely within our jurisdiction, who are subject to our laws, that we think of making citizens. Congress satisfied this language. They put that all into that one key phrase, and it's now in the 14th Amendment. Now, the phrase subject to the jurisdiction thereof, Clarence Thomas continues, solved the problem because it avoided excluding from citizenship the children of non-tribal Indians. Like temporary visitors, tribal Indians were not subject to our jurisdiction because they didn't owe allegiance solely to the United States. They governed themselves in their tribes, marriages, family matters, intestacy, payment of personal taxes, all regulated there. And similarly, people passing through who are temporary visitors, they owe allegiance to another government. Their domicile is there. They're not subject to the jurisdiction of the United States. They're going to drop a baby off and fly right back to China. They don't live here. The evidence from decades following ratification confirm that the citizenship clause was understood to exclude children of temporary visitors. Clear as day. 10 times as thorough as anything the majority just dumped. There was frequently expressed, enduring and widespread agreement that the clause did not guarantee citizenship to persons not domiciled here. Everyone agreed. And the executive branch understood that. In 1873, Ulysses S. Grant interpreted it to mean only to persons over whom the U.S. had complete jurisdiction, meaning ours only. not ours and Guatemala, not ours and El Salvador or Mexico or whatever. Across administrations, the executive branch took the same position. A child born on American soil was not an American citizen when he was domiciled in a foreign country or China. By virtue of being a foreign domicile, he was on his birth subject to them, not subject to us. And so a child born here to a foreign father, when taken by his father abroad, acquires the father's domicile and the father's nationality back in their home country. These were not mere abstract positions. Clarence says this was the executive branch and their operating rule and their decision for decades. When the children of temporary visitors born on American soil claimed to be citizens based on the clause, the executive branch repeatedly denied it. Joseph Speck was denied citizenship after being born in the U.S. to parents domiciled in Switzerland. Jurgen Afuera. Ludwig Hausding was denied citizenship after being born in the United States to parents domiciled in Saxony. Jurgen. Cleveland, the president's secretary, said, "You're not a citizen here. You are not domiciled here, and you're subject to a foreign power. So no citizenship for you." Richard Gracier. Parents lived in Germany. His father was domiciled in Germany. So you're not a citizen. You're a German, because that's where your parents are from. Friedrich was denied citizenship after he was born in the U.S. to parents domiciled in Austria. When he sought protection, they said no. Even though you're born in New York, your parents are temporarily here. And they returned to Europe a few years later. You are not a citizen. The child of a woman named Mary Devereaux was denied citizenship after being born in the U.S. in 1889. Devereaux was an Irish woman who arrived in New York, went to the hospital, and gave birth the next day, anchor babies in 1889. She was not yet, though, lawfully admitted to the country. Although the baby was undoubtedly born on American soil, it was not an American because Devereaux had not been lawfully admitted. Oh, so that didn't count. Where's all this history in the majority opinion? How come they skimmed over all this, didn't even include it? They said, you're not a citizen. You can't come here and just drop a baby off and have it count. You're Irish, your child's Irish. These children were not born to diplomats, okay? They were not part of invading armies or Indian tribes. They were simply foreigners born on American soil but not domiciled here, says Clarence Thomas. And they were all denied citizenship under this clause by those in a better position to know the original meaning than Amy Coney Barrett is. Even the most expansive executive interpretation of the citizenship clause ultimately denied citizenship to a child born here but domiciled abroad. Another one, Francois Heinrich, born of parents who ultimately returned to their native Austria. He claimed to be an American citizen. Grant didn't say. He said he was originally clothed with American nationality, but it then promptly denied the claim to be a citizen. Heinrich was instead, despite being born on soil of America, a citizen of Austria. He was domiciled there. And he's an Austrian subject. He's treated as such and not an American citizen. So Congress understood this to also exclude children of temporary visitors. Just 2 years after the 14th Amendment was ratified, Congress passed the Enforcement Act. The act implemented the citizenship clause with the same language the civil rights had used. They said back then in 1870, not subject to any other foreign power. The 1870 Act thus incorporated the language that expressly excluded the children of temporary foreign visitors who were subject to the power of the foreign countries in which they were domiciled. If the clause included the children of them who clearly fall outside the reach of the Enforcement Act, then the Reconstruction Congress would have violated its own citizenship clause in an act designed to enforce it. The parties point to no one who suggests that the act was unconstitutional at all. So this court, says Clarence, long agreed that the citizenship clause did not apply to persons born here to temporary visitors. Just 5 years after the clause was ratified, the court explained the phrase subject to the jurisdiction excluded people not domiciled here. The phrase, the court explained, was intended to exclude children of ministers, consuls, and citizens or subjects of foreign states born in the U.S., slaughterhouse cases, a citizen of a foreign state who invades the border is excluded. Then in Elk, another case, the court again interpreted the clause. It requires complete jurisdiction, allegiance to, acquiescence to, not just bare territorial authority, which is ridiculous. The court held that to satisfy this, a person must not only be born here, but also must, quote, be completely subject to the U.S. and completely subject to the political jurisdiction at the time of birth. The clause's evident meaning is not merely subject in some respect or degree to the jurisdiction. It's subject completely to the political jurisdiction and owing direct and immediate allegiance. Now, the clause thus granted citizenship at birth only to persons who owed no allegiance to any foreign power. And all of the illegal aliens owe allegiance to their home countries. They're citizens of their home countries. Of course, the children of temporary visitors were not completely subject to the political jurisdiction, and they did not owe the U.S. immediate allegiance, and so they did not and did in turn owe allegiance to an alien power. So Justice Harlan dissented in Elk, but he agreed that the clause referred to complete jurisdiction, dissenting only because he thought someone born in a territorial United States could become a citizen even if he became subject to its complete jurisdiction later in life. His view was not uncommon at the time. The clause did not require that a person be born while subject to complete jurisdiction, just that you could be born while not subject and then become subject later. You can abandon your prior nation state or your prior Indian tribe. Now, the most celebrated 14th Amendment opinion is the dissent in Plessy versus Ferguson. In that dissent, Justice Harlan disagreed with Plessy's conclusion that the Constitution tolerated state-imposed segregation, separate but equal. Justice Harlan took the position that to be vindicated years later, he said, our Constitution is colorblind. It knows neither nor tolerates classes among citizens. He also took a view on whom the citizenship clause applied and did not apply to. According to Harlan, the clause did not apply to persons born here who resided abroad. It gave citizenship to all persons born or naturalized here and residing here. Clarence continues in this burner. He says state officials likewise agreed that the clause excluded persons not domiciled here. Although the clause guaranteed both national and state citizenship, states excluded from citizenship children of transient aliens. Even the states agreed. And state precedent also held children born of foreign parents only get citizenship at the state level when they are domiciled here, 1895 case. You got to be born here, you got to be subject to the jurisdiction thereof, and you got to not be subject to any other foreign power. Scholars agree with us as well. Long list of these people that require those conditions. He lists them here. Thomas Cooley, Francis Wharton, Henry Campbell, and more. Cooley wrote about it, and Francis wrote about it, and Henry Campbell Black wrote about it. He said, if a stranger or traveler passing through the country temporarily has a child here who goes out of the country with his father, that child is not a citizen. Scholar after scholar confirmed domicile is required. The word subject to the jurisdiction excluded the children of foreigners transiting through. The clause also excluded children of foreign subjects born while the latter transiently sojourns there. If you're subject to a foreign power and you have a baby here, you are not totally subject to our jurisdiction. You're subject to theirs. Then as immigration laws became more restrictive, some adopted the view that children must be born to citizens to obtain citizenship by birth. In contesting that view, its detractors spoke in terms of domicile. Others published articles that said domicile's enough, so they're attacking it from the other way. If you live here, they said that's good enough. In Wong Kim Ark, the court interpreted the citizenship clause again to apply to birth and domicile. In this case, this was about Chinese immigrants. Hundreds of thousands of Chinese immigrated to the United States. They were met with considerable hostility, and Chinese settlers by statute could not be naturalized in the United States. Congress then banned Chinese immigration in the Chinese Exclusion Act. And meanwhile, if a Chinese person, though, renounced his allegiance to China, the Chinese government would behead him if he returned, sell his family as slaves, and banish his relatives. Unlike other settlers, then, the Chinese, even those who lived here and wished to remain, they had no pathway to citizenship, no means of freeing themselves. The branch of the executive took the view that because domicile no longer ensured full integration into the American body politique, the citizenship clause phrase, subject to the jurisdiction, must require more than domicile. That would entail that a child born to Chinese parents domiciled was not a citizen. The executive then sought to replace that requirement of domicile, which would make any child of a domiciled immigrant from China here, with a requirement that the parents are citizens, not just domicile, citizens. So then they made it harder. Acting on this view, the government denied citizenship to the guy in Wong Kim Ark. The facts are obvious here. Wong Kim Ark was born in San Francisco in 1873. His legal home was California. His parents were not temporary visitors. They were not illegal aliens in Wong Kim Ark, says Clarence Thomas. True. Instead, his parents had done everything within their power to express their desire to become Americans. They came to settle in America. After Wong traveled to China in 1890, he returned and was admitted as a citizen. But after his second trip to China, the American's custom collector said no. The government said, "You're not a citizen. You were not born to citizen parents, even though they were lawfully domiciled here." This court's decision in Wong Kim Ark concerned only persons already domiciled here. As stated in the government's brief, the question is a person born to alien parents domiciled therein and thereof by the fact of his birth? So in the Wong Kim Ark case, that's the question. The government said Wong was born and domiciled here, and the thrust of the opening brief was that birth and domicile were insufficient. You got to be connected by blood, jus sanguinis, to a parent who is a citizen in order to confer citizenship status. The government lamented the mistakes made and the misunderstanding that arised from failing to distinguish between nationality and domicile. The government disapproved of the decisions of some of our attorney generals and their error in failing to distinguish between domicile and nationality. It acknowledged that state citizenship was based on domicile, but argued that a different rule should govern citizenship to preserve the distinction between state and national sovereignty. The Constitution does not countenance, the government argued, making domicile an element of nationality, but the court was not persuaded by the government and said that Wong, born in the U.S. to parents domiciled here legally, lawfully, with permission of the country, was a citizen, so he counts. Now, the court found it so important that Wong and his parents were domiciled here that it gratuitously insisted upon that fact throughout its opinion. The court's introduction paragraph stated 7 different ways that Wong was domiciled here. He was born to parents who were at the time domiciled legally. His parents were enjoying a permanent domicile, like a green card, lawful permanent domicile and residence there. His parents continued, it was ongoing, so it was permanent, to reside and remain, quote, he ever since his birth had one residence in California. He had there resided. He never lost or changed his residence. He never gained or acquired another residence. And 2 paragraphs later, the court also confirmed that its decision was limited to persons born and domiciled in the U.S. The question presented by the record is whether a child born in the U.S. of parents of Chinese descent who at the time of birth are subjects of China, but who have a permanent domicile and residence. Okay, it's like a green card, lawful permanent residence. that kid becomes a citizen at birth. Then, if that were not enough, the court reiterated the same limits to its opinion in the final paragraph. They said this case presented for determination, the single question is whether a child born in the U.S. of Chinese descendants at the time of the birth are even if they're the subject of the Emperor of China, if they have a permanent domicile and residence. And illegal aliens do not. The opinion itself was filled with meandering dicta, a bunch of nonsense that doesn't relate to the holding. The court's interpretation of the citizenship clause evolved over the course of the opinion before landing on this interpretation. At first, the opinion stated that the rule of American citizenship was a feudal principle of birth, with only two exceptions: ambassadors and alien enemies. Like, you can have an invading army that comes in and has babies and they count as citizens from your foreign invaders, which is basically what's happening right now. Then after considering more evidence, the opinion then reformulated the rule, and then going on and on and on, they then landed on the final rule. And all said and done, it's about domicile. So although these various statements are both dicta and irreconcilable, it's like a meander, it's like 1898 or whatever, the decision is born in and domiciled lawfully and permanently in the United States. And even in the dissent on that one, there was tension with the view that it's about complete jurisdiction. Those were Chinese subjects of the emperor. He said in Fuller, the dissent, he rejected the premise that the parents were even domiciled here. He said that because Chinese law purported to bind Wong's family even after they were here, they can't have a permanent home here, no matter what length of their stay may be. So no citizenship for him. Thus, Chief Justice Fuller and Harlan dissented in their view because Wong and his parents were not actually domiciled in here at the time of the birth. So it's either domicile or they're not domiciled. So Wong Kim Ark left in place the same rule that existed before. A child of a domiciliary was a citizen, but a child of a temporary visitor was not. And a legal scholar explained thereafter that the point of it is to make citizens of the United States under the 14th Amendment if they are permanently domiciled and residing here. Another treatise explains that and more. Now, on this understanding, temporary visiting children were still excluded. In the U.S., someone else wrote about this 6 years later and agreed. In 1901, another treatise said the same. In John Westlake's book in 1904, it said the same. Transient purposes are not enough to confer citizenship. So this understanding was widespread. A person born in the country of alien parents was a citizen only if those alien parents were domiciled. It went on. It doesn't translate over to temporary people. Government officials generally agreed in 1910, a DOJ report explained, it has never been held, and it is very doubtful whether it will ever be held, that the mere act of birth of a child on American soil to parents who are accidentally or temporarily here operates to give that child all the rights of citizenship. In 1910, it is very doubtful whether it will be held. That didn't work out today because John Roberts and Amy Coney Barrett's. Even this court described Wong Kim Ark as limited to domicile. Now, throughout this period, Congress left in place the same language that it originally enacted in 1866. You have to not be subject to any foreign power. The Nationality Act of 1940 replaced the language with the same language here. In the clause, person born in the U.S. and subject to the jurisdiction thereof. Then in the 20th century, executive practice repurposed the clause to treat the children of temporary visitors as illegal aliens, as citizens. An assistant solicitor general called Richard Flournoy prominently said the clause does not include children of temporary visitors. He disagreed with a number of writers who held that in order for a person to be born here, his parents must have been domiciled and more. Although he acknowledged that Wong Kim Ark did not directly decide that point, he said that the citizenship clause should be read to incorporate a rule that originated with the feudal system, under which all persons, with certain limited exceptions, born within the fiefdom over a lord owing a fealty to him counted. He acknowledged that some consequences, though, are absurd. And then FDR came in, and they adopted the view that the clause applied to children of even temporary visitors. FDR, you piece of... In 1995, then, some 127 years later, Clinton, they endorsed the same view. They explained that the right to American citizenship for children of illegal aliens and temporary visitors is fundamental to our liberty as we understand it. Bill Clinton selling the country out. How is giving citizenship to illegal aliens beneficial to our liberty? Can somebody explain that? Many in Congress disagreed. In the 1990s, Harry Reid sponsored legislation that would clarify, he was a Democrat, that the child of an illegal alien or temporary visitor would not be a citizen, only for plopping a baby down here. He said no sane country would offer a reward for being an illegal immigrant. Others supported similar legislation, but now the Democratic Party knows that this is how they shape and reconstitute the entire fabric of America. The question was not prominent in judicial opinions. One of the first substantial discussions came 105 years after Wong Kim Ark. Somebody said a constitutional amendment may require to be changed the rule where you get automatic citizenship, but he said, but I doubt it. The purpose of the rule was to grant citizenship to the freed slaves and would not be flouting the Constitution to put an end to the nonsense. Now, some took advantage of this recent policy of granting citizenship to everybody. The policy then created this concept called birth tourism, the practice of traveling here with temporary authorizations solely to give birth and obtain citizenship for one's children. Then returning to raise them in another country. Happening right now. Have My Baby in Miami is a whole company that's set up to help hollow out America by allowing foreigners to come in and get citizenship. Today, birth tourism companies collect large fees from wealthy foreigners to do this. Large numbers of children are born in the United States each year to parents who are here temporarily just to get citizenship. Here's an article, Why Chinese Parents Come to America to Give Birth. Now, upon taking office, Trump said, enough of this crap. The order adopts the view 14th Amendment doesn't apply to temporary visitors or illegal aliens. It says someone born in the U.S. is not guaranteed citizenship if either of those apply. Section 2 of the order directs the branch to enforce this interpretation. Don't issue documents to foreign invaders. Those directives are not prospective. They apply only to people who are born within the U.S. 30 days after the date of this order. Now, the initiative generated a groundswell of new scholarship. A wide range of originalist scholars have concluded that the 20th century executive practice was mistaken and that the order was lawful. Many people writing about it. But before the order went into effect, several lower-level district courts universally stopped it. This court partially stayed these injunctions because they exceeded the remedial authority. Several plaintiffs then sued new actions, and again, Trump was injuncted. So this case comes from one of those actions. Here, 3 plaintiffs sued. They who proceed under pseudonyms and are now, I guess, in charge of the country, are each illegal aliens or lawful temporary visitors. The first one is a Honduran citizen. They were expecting a baby in 25. The other were a Taiwanese and a Brazilian. They didn't say that they were even expecting a baby. None alleged that any of their children will be domiciled in the U.S., and as a right of action, they invoked the citizenship clause. They sued on behalf of all other illegals and temporaries to have this declared unconstitutional. The district court found in their favor, said everybody gets citizenship. You all do, so do you. Come on in here, make it a free-for-all, and entered a class-wide injunction stopping Trump from enforcing the order. So the court today, writes Clarence Thomas, affirms this, affirming a universal class injunction. It says that the Constitution, the 14th Amendment, guarantees citizenship to all children born here, to lawful temporary visitors legally here, temporarily, or to illegal aliens. On the court's telling, the law of citizenship in the United States was fixed to an English rule that everyone born on the soil was permanently bound to serve the sovereign. We're all just essentially slaves. There is no allegiance. There is no choice. This principle of permanent feudal allegiance, according to the court, was repurposed into the rule of citizenship that was adopted by all the states. The rule's universal acceptance was embodied by an 1844 state equity decision called Lynch. The rule then extended citizenship to all persons born here just by territory, except for 3 categories: foreign representatives, children over whom the government lacked actual power, and children of Indians and tribes. Those 3 exceptions were then adopted in the Civil Rights Act and then Enforcement Act afterwards, and then incorporated in the Citizenship Clause. And the opinion on Wong Kim Ark, they say, is the same rule. But Clarence says, no, it isn't. Before proceeding to the merits, I briefly note 3 threshold impediments to this court's decision today that the court leaves unaddressed. First is about an independent obligation. And we have an independent obligation to ensure that every single recipient of a class action has standing. But today, you don't do that. All you're doing is granting this to everybody everywhere without even confirming that they have a basis to be in this court. So it's a procedural objection. And second, the court cannot grant relief to any party without a right of action. But you grant relief here. And these laws don't even create the right to sue. They have no right to sue under this. And so the APA says you can only sue under final agency action, but that never happened here. So they really shouldn't even be suing at all, period. And third, because the respondents sought to invalidate the district court's order in its entirety, the plaintiffs bear the burden of showing that all applications of the order are unlawful. So they should be able to sue one by one, but you should not be granting procedurally a blanket set of relief for every illegal alien across the country. But you did that. The court's decision to hold this order facially unconstitutional makes it unlawful for the president to enforce the order against anyone. He cannot enforce the order against the child of an illegal alien or even the child of a foreign spy. He cannot even enforce the order against children who were raised in a foreign country, come here, plop their baby, go back to China, nothing they can do. Join foreign armies, nothing they can do. They're citizens that come back in. Fight wars against the United States, totally screwed. The court, without considering any of these things or even mentioning them, holds unconstitutional everything, all of it. But in my view, this order from Trump is not facially unconstitutional. The order is consistent with the original meaning of the Citizenship Clause, at least insofar as it applies to children born to parents here lawfully or unlawfully who are not domiciled here. The clause was enacted for people who were born in this country and called it home. It was enacted for freed slaves like Dred Scott who had domicile here. It was enacted for men like Frederick Douglass who demanded citizenship. As Americans, its authors and supporters promised over and over again that it would exclude the children of persons temporarily here whom we have no right to make citizens. In Senator Trumbull's words, who is quoted by the majority, what do we mean by subject to the jurisdiction of the United States? He says, not owing allegiance to anybody else. That is what it means. And for decades after ratification, it was interpreted by all 3 branches of government and a wide range of legal authorities to be limited to people who were already Americans. And so the ordinary principles of constitutional interpretation, the ones on which this court typically relies when answering questions like this, support our interpretation. It requires domicile. That conclusion is supported by the constitutional text, the contemporary evidence, early executive practice, how they actually impose the law, early legislative practice, judicial precedent, all of the other indicators of public meaning. Your alternative account does not have a similar degree of support. So the order is therefore, insofar as it applies to domicile, consistent with the 14th Amendment. It is consistent with the clause in its exclusion of children of lawful temporary visitors, visas, like birth tourists. The exclusion of the children of lawful visitors who are by definition not domiciled here was originally a matter of widespread agreement. And as to them, the order does exactly what the executive branch did for most of the 19th century. What this court said that it could do, and what scholars for decades confirmed that it could do. And the order is at least facially consistent with the clause in excluding the children of illegal aliens because at least some such persons are not domiciled here, and therefore they are not citizens. And so the text supports the conclusion that citizenship requires domicile. Subject to the jurisdiction means that. It means domicile, so that we've got control over your personal affairs, power to regulate your conduct, power to impose taxes. It also provides a reciprocal relationship of primary allegiance. A government lacked the powers associated with this relationship, lacked complete jurisdiction over the temporary visitors. The temporary visitors are still subject to their home countries. This interpretation is consistent with the debates where they said not subject to any foreign power, even in the prior Civil Rights Act. It's consistent with the early American law about domicile. It overrules Dred Scott. Why? That case was domicile. It excludes tribal Indians because of jurisdiction and allegiance. And it ensures that the freedmen who were clearly American would not be denied citizenship based on a racial caste system. And so, in other words, says Clarence Thomas, the phrase subject to the jurisdiction meant what the drafters and ratifiers said it meant. Complete jurisdiction, fully and completely subject to America. The jurisdiction of the United States in every sense, a full and complete jurisdiction, coextensive in all respects with the constitutional powers of the country. The phrase thus had the implication that the drafters and ratifiers said it had. The children of temporary visitors were not citizens. The clause said we would not, of course, include persons born to foreigners or aliens or ambassadors or ministers. We would have no right to make citizens of people temporarily here. And so the alternative theory is more difficult to square with the text. The court in the majority, Amy and Roberts and the leftists, defined the phrase as subject to the jurisdiction to mean the power of the U.S. to govern the territory. That it's our land. That means you're our jurisdiction. That's the analysis. It then says that at least 3 categories of persons, though, are excluded, which is weird if that's the rule. Why the exclusions? First, a person is not subject when the government waives its power over them. The court understands this category to exempt children of foreign sovereigns. Although the court gestures towards diplomatic immunity for this logic, that only extends to a narrow set of people. Most foreign officials have partial immunity, like immunity for official acts, but partial immunity cannot render a person not subject to the jurisdiction in their interpretation. After all, a variety of clearly American government officers like judges, prosecutors, and police officers have immunity. And furthermore, if the political branches can deny someone citizenship by waiving their power over them, then they can deny citizenship to any child in America, even if his family's lived here for generations and he has no other home. So where does that come from? The better explanation for excluding children of foreign reps is that they are not domiciled here. What is the limiting principle on the rule? It's domicile. It's not some made up exception. And second, the court says that a person is not subject to the jurisdiction when the government lacks actual power over them. Okay, this category presumably is an attempt to accommodate the consensus that citizenship would not have been granted to the children of foreign invaders. But while the child of a foreign invader is, of course, not constitutionally entitled to citizenship, it is not because America lacks actual power over him. What? If it were, then citizenship could be denied to any American over whom the government happens to lack actual power. What? I mean, if you're an illegal alien who's floating around and nobody knows where you are, then does the government have power over you? You're kind of in hidden sight. Nobody can see you. The more likely reason why foreigners are not citizens, it's domicile. The third one is when you're a member of an alien and sovereign nation. This category, again, is trying to accommodate Indians. But the court cannot explain why tribal Indians were not subject to the jurisdiction if they were born outside Indian lands. It is true that tribal Indians belonged to alien and sovereign nations and that the U.S. relations implicated them, but temporarily visiting foreigners also belong to alien and sovereign nations. So it's difficult to understand why China, for example, would be less alien or less sovereign than the Cherokee. It is also difficult to understand why tribal Indians would be less entitled to American citizenship if born on non-Indian land within the U.S. than the children of birth tourists who immediately come here and return to China. And the court can't reconcile their new definition. The court does not attempt to explain how its reading is consistent with the Civil Rights Act. The court does not present evidence about anything about not subject to any foreign power. Temporary visitors are subject to foreign power. The court also doesn't present any evidence of the citizenship clause that it had a different meaning than the Civil Rights Act, as no party here disputes the two provisions were agreed to have been synonymous with respect to foreigners. And so the court also cannot explain the evidence that citizenship in this country was instead based on domicile. It doesn't even engage with the debates. It has no account of why many legislators made so many statements irreconcilable with their view. In fact, the court does not even identify anyone who expressed the feudal principle in the relevant language, not subject to any foreign power or subject to the jurisdiction. The closest they come is to this Lynch case, which uses the phrase within the jurisdiction. But Congress didn't use that phrase. They said that no state may deny any person within its jurisdiction equal protection of the laws, so they know how to use that phrase. But the citizenship clause did not say within, it said subject to. So it has meaning. In other parts of the 14th Amendment, they say within the jurisdiction, but subject to means something very different than that. And so while jurisdiction can refer to territorial jurisdiction, the clause does not adopt that interpretation of jurisdiction. So I would not, says Clarence Thomas, interpret subject to the jurisdiction to refer to the exclusion of those three categories. There is a simpler interpretation. It's about domicile and complete jurisdiction. Those children born to diplomats, hostile alien occupiers, thank you, and Indians and tribes were not citizens because they were not subject to complete jurisdiction. And for the same reason, the children of temporary visitors who are also not subject to the complete jurisdiction are also not citizens. And Clarence continues, practice and precedent immediately and long following ratification support the same conclusion. In constitutional law, this court often pays close attention as to how these things were interpreted. And here, everybody interpreted this to require domicile. The executive branch regularly denied citizenship to children of temporary visitors. We've seen that before. Why? They're not domiciled here. They're not subject to the complete jurisdiction thereof. It's happened many times. In recorded reasoned decisions, the Hayes, the Cleveland, the Harrison presidential administrations, even Grant, all denied citizenship to children born in the U.S. but not domiciled here. Against this settled course of practice, the court can find only a single decision in the entire 19th century that believes it supports its interpretation. But in that case, the executive branch ultimately ruled that the claimant, Francois Heinrich, was not a citizen. He was born on American soil, did not fall into any of the exceptions, and they said, not a citizen, go home. The court understands the executive branch to have concluded that he was originally clothed in American nationality, but then lost it once he returned his domicile abroad. So even the court is thus forced to embrace an interpretation that allows the political branches to deny citizenship to persons born here, and on that interpretation, they can deny it once they go home. But beyond that case, the majority does not dispute that there were many other 19th century executive decisions that are incompatible with its view, and it has found no examples of the executive branch actually affording the privileges of citizenship to a person born here while domiciled abroad. And so they are contradictory. And Congress supports this as well. Congress could have included those three exceptions if they wanted to. They didn't. Instead, they said if you are subject to any foreign power, you don't count. Once again, a foreigner who is not domiciled here remains subject to the foreign nation, his home country. Nobody in Congress, says Clarence, as far as I'm aware, argued this exclusionary language violated the citizenship clause. And so Congress left the language excluding subject to any foreign power in place until 1940. It was the governing rule for 72 years after the 14th Amendment. And you have no explanation, John, for the Reconstruction Congress's 1870 decision to exclude from citizenship all persons subject to any foreign power. You appear to concede that it cannot reconcile your interpretation of that citizenship clause in the 14th with that law. Why is this in here if after the 14th Amendment is passed, it means everybody anywhere all the time all at once? The court recognizes that every child born to temporary visitors was subject to a foreign power. And so according to the court then, Congress defied the clause immediately after enacting it. How could that be? Early judicial precedent also supports the same thing. In 1873, 5 years after the ratification, this court described the citizenship clause in a manner that is, on the court's view, indefensible. This court, Supreme Court, said the clause excluded from its operation children of foreign states who are citizens or subjects of foreign states in the slaughterhouse cases. The court rejects that position today, but doesn't want to address its prior interpretation. And similarly, in 1884, this court interpreted the clause to require that a person be not merely subject in some respect or degree to the jurisdiction of the states, but completely subject to its jurisdiction. Direct and immediate allegiance. No allegiance to any alien power. The court rejects that one too. So are you overruling those cases without commenting or explaining why? Decades of post-ratification scholarship also confirm this. Many interpreters concluded domicile. Scholars said children born here of alien parents who show they're permanently domiciled and excluding those with allegiance to some other government are the mechanisms. Many more agreed. He's citing a bunch of cases here, bunch of books, Black Handbook, Foreign Powers and Jurisdiction of the British Crown, some law review article over here. And so it excludes children of persons passing through or temporarily here. But the court doesn't care. Doesn't even attempt to match this post-ratification evidence. To the contrary, the court acknowledges that at least by the 1880s, the clause was understood to require domicile by the government and executive branch and others note. The court, though, proposes this widespread understanding was not evidence of the original public meaning of the clause, but a rebellion against it. The court and other governments who held that domicile was required, they were trying to reform the law. It was a post hoc adjustment. Their motive, the court seems to say, was to deny citizenship to the Chinese, especially around the election of Cleveland, the first Democrat to hold office. And so on this basis, the court says that ignoring considerable post-ratification practice and scholarship, it says we're just going to ignore all that because they were trying to change the rule after the fact. But that doesn't even make any sense, says Clarence Thomas. To begin, the post-ratification evidence against their view begins not nearly 2 decades after, but immediately after. Well before the court has any explanation for a departure, all 3 branches of government had already rejected it. This wasn't like a modification in the 1950s. Immediately in 1870, Congress said citizenship means a child born here not subject to any foreign power. Then 3 years later, the Supreme Court in 1873 said citizenship clause means exclude from its operation any citizens or subjects of foreign states. And the same year, Grant also interpreted it to exclude the children of aliens over whom the United States has limited jurisdiction, even though they were born here. If all three branches of the federal government were not enough, many others concurred with this. And Roberts and Amy Coney Barrett cannot explain why. Why, in the 1870s, why did William Robinson write that children born within the territory of alien parents were not citizens unless they had permanent domicile? Why, John, why did Representative Ebenezer Hoare, Grant's first AG and one of the nation's most eminent jurists, interpret the clause to require domicile? How come? And why did the executive branch deny citizenship to children born here but domiciled abroad? The court cannot explain why. In 1880, Thomas Cooley wrote that the clause excluded children who had any allegiance to some foreign government. Well, we know why. Because they want an outcome in a political fashion. The court's theory does not even explain the later evidence that it characterized as revisionist. If, as the court suggests, various government officials and scholars were trying to stop the Chinese, then they would not have proposed a domicile requirement alone. They would need a citizenship requirement, as we saw in Wong Kim Ark. They wanted more. You're only a citizen, not if you just live here, but if you are connected to a parent citizen. Meanwhile, as far as I can tell, the people excluded by the domicile requirement were not Chinese, but they were mostly European. And so the most likely explanation for why so many Americans said that citizenship required domicile is probably because, citizenship required domicile. Now, many other indicators of the original meeting support this. First, I want to talk about if the court were right that it did not require domicile, then it would have increased dual nationality, and that would have provoked a lot of concern. The U.S. has long recognized the undesirability of dual allegiances. Yeah, we do. We see it's literally destroying the country. You have people in sanctuary cities waving around their foreign flags who say that they are reconquering America and that we're on stolen land. You've got people in Congress who care more about their foreign countries from where they immigrated than they do about America. We see foreign flags all over the place. It's disgusting. And it's going to be the downfall of America unless we have a real serious response to this thing. The view at the time was that a nation should as soon tolerate a man with two wives as a man with two countries. Yeah, cheaters is what they are. They're cheating on America. Opposition to dual nationality was especially strong after the Civil War. The country had just emerged from a civil war that cost the lives of 600,000 men due to a treasonous denial of allegiance. In 1868, a congressional report explained that if a person was a national of both his home country and birthplace, then he could have competing claims for compulsory military service. And we don't want it. And so a rule that recognized the citizenship of children born to temporary visitors would create dual citizens. And at the adoption of the clause today, most nations treat the children of their citizens born while abroad as citizens. So now these kids are dual citizens. They're not just Americans. As a result, a child born in the United States of a temporary visitor would have immediately been a citizen of his home nation. If the court's interpretation were correct, the child would immediately become a dual citizen. And it's unlikely that after the Civil War, we would have wanted that. By contrast, domicile mitigated the problem because you can only be in one place at one time. So tying citizenship to domicile avoided dual citizenship. Second, the domicile rule aligns national citizenship with the longstanding rule of state citizenship. Even after today's decision, Americans are citizens of only their state of domicile, even if it is not the state of their birth. No one doubts that a child born to New Yorkers on vacation in Florida would be treated as domiciled in New York. For the same reason, one would think that a child born to Canadians on vacation in Florida should not be a citizen of the United States. The court, in other words, rejects this and is bewildered by an approach to citizenship that is, in fact, the one we still know best. Third, the domicile rule would make citizenship clause accord with America's treatments of its own domiciliaries abroad. America itself has long taken the position that children of American citizens born on temporary visits abroad are Americans. Such children were long considered American citizens because their parents were domiciled in America. And so it's unclear why the same reasoning should not apply the other direction. Now, your alternative history is also mistaken. The theory of the citizenship clause stands on 3 pillars. Clarence just keeps going, man. He's like, not letting it stand. We're happy. Calvin's case, Lynch versus Clark, and Wong Kim Mark, and none of these cases can stand. The first pillar of Roberts' decision is Calvin's case, a 418-year-old English common law case. That case held that a child born in Scotland could hold land in England. According to the court, Sir Edward Coke's separate opinion in that case established the common law principle of jus soli, place of birth by soil, pursuant to the people owed a perpetual duty to the king. This principle applied to everybody on that land, not just domicile. And as the court says, for some reason, this 1608 feudal principle is now America's principle. The English principle was a rule of feudal servitude, not citizenship. In England, there was no such thing as a citizen. The English principle determined a person's feudal bondage, and he couldn't even abandon that. It was based on a notion he owed a personal service to the lord of the soil. Every owner of the land held them subject to the superior on the land. We did not accept that in America. We had a whole revolution over it. And as Alito explains coming up, the principle that birth on the soil made a person perpetually bound to the king, and the king was anointed by God, is what we're doing in America now. John Adams famously wrote that the feudal theory meant that the common people were held together in herds or clans in a state of servile dependence on their lords. And that is in direct opposition to America. We had a Declaration of Independence. We dissolved all allegiance to the British crown. We're not doing that anymore. And they set up a new system where the people are not servile dependents. The people are sovereign, and the government derives its legitimacy from we the people. In this new system, feudalism has no place. The soil did not belong to the government. It belongs to us. And those who were born on it did not owe the government a lifetime of obeisance or servitude. And so the Reconstruction Congress expressly opposed the feudalism that John Roberts says it adopted. As its Committee on Foreign Affairs saw the matter, there was nothing American in the oath of the land barons of England. 1868 had a report. It described the English rules claim of indefeasible allegiance and perpetual service as a symbol of feudalism. And we're not doing that. We have citizenship here, and citizenship is domicile. The same year the Citizenship Clause was ratified, Congress passed a law rejecting the feudal principle and explaining that it supported the right of all persons to change your citizenship. You're not a subject you can renounce. Now, in fact, by the 1840s, even English law had evolved. England had moved on from the darkness of the Middle Ages as, quote, the subjects of one kingdom began to migrate and reside in other countries, and then had a newfound importance of the law of domicile, saying well before the Citizenship Clause, the court explained the courts of England decided that a person who removes to a foreign country, settles himself there, and permanently remains, stamps him with the national character of where he resides. And a year after the Citizenship Clause, a renowned English case declared that a person's civil status by virtue of which he has ascribed to him by the character of a citizen of some country is governed only by one single principle, namely that of the domicile. Now, the second case is Lynch. This is a single state court case from 1844. Thomas Lynch was a successful businessman. When he died, he had no will, no children. Shortly after he died, his brother and niece, through another brother, Julia, moved to New York from Ireland. The New York legislature then passed a special law giving Lynch's property to Julia. subject only to the rights of the heirs of Thomas. The legislature then passed another law giving Lynch's property to Bernard, and many people claimed the property. Bernard then brought a bill in equity against both Julia and Clark. Julia cited the special statute giving her inheritance, and that argument turned on a state law bar on aliens inheriting property. But she says, I'm not an alien. She says, I'm not an alien because I live here at the time of my birth, and my father came here with the intention to remain. And the assistant vice chancellor, who was assigned to the case over property, during the citizenship said that argument was not made on a very prominent point. And he wrote a long opinion explaining his theory of American citizenship. And it said that Julia was not an alien, but a citizen. And so she can inherit property in this case. So Clarence is basically saying, what the hell kind of case is this? It's like a property case, property law. The court's reverence for Lynch is not commensurate with its importance. Lynch was not a precedent of this court or any federal court or any state appellate court or even a court of law. It was decided by a New York assistant vice chancellor in a court of equity similar to a trial court. The vice chancellor, much like a magistrate judge, had the power to hear motions and settle these things. And so this is what you're hanging your hat on? That case did not even interpret the citizenship clause at all. It used a statute that had similar language, but they interpreted state law. The state law was replaced immediately after it was over. And so this is where your holding comes from. And Lynch also lacked the staying power. By the time of the citizenship clause, New York's higher courts had all but abrogated it. In Ludlam versus Ludlam, a New York court held that the children of those traveling or sojourning abroad, though born in a foreign country, are not born under the allegiance and are an exception to the rule which makes the place of birth the test of the citizenship. So they reversed themselves. And all of that made up John Roberts' opinion. So then during the 14th Amendment debate, Lynch went completely unmentioned. No one even talked about it. It was only during the civil rights debates that Lynch appeared, a single mention by a member who played no role in the drafting of the 14th Amendment at all. So while this court's opinion invokes Lynch 13 times in 26 crap pages, the entire Reconstruction Congress, in the combined course of deliberations over the Civil Rights Act and the Citizenship Clause, mentioned it only once. The third pillar of the court's theory, Wong Kim Ark, is on the question of whether the Citizenship Clause requires the president to recognize citizens of lawful temporary visitors and illegal aliens. Our question today was not the question before Wong Kim Ark. In Wong Kim Ark, the court said that that was someone who was born in America to parents domiciled here was a citizen. That's not what this question is. Now before the court is temporary visitors, no domicile, illegal aliens, no domicile. It rejected the government's argument that Wong's parents had to be citizens for him to be a citizen at birth. Now, this order is fully consistent with Wong Kim Ark. Under Trump's order, people like Wong remain citizens, and the government today nowhere urges the position that it took in Wong Kim. To the contrary, it invokes the authorities that the government in Wong Kim opposed, and the court nonetheless, though, leans heavily on dicta from the majority opinion, which it takes to have established the fact that domicile was irrelevant and that he, a lifelong American, was indistinguishable from a person who comes over and has no meaningful ties to America at all. They're all the same now. Now, the court does not ordinarily put so much weight on a past decision discussion of matters not before the court. It is a maxim not to be disregarded. This court has always admonished that general expressions in every opinion are to be taken in connection with the case where those expressions are used. So if it goes beyond the case, they may be respected, but shouldn't control the judgment. We shouldn't make our decisions based on dicta. And same here. This is not even clearly on your side. After a long discussion with many inconsistent internal statements, Wong Kim's final statement is more in alignment with the citizenship order. It says in the order, and Wong Kim also said that there are exceptions But in their decision, it was resident aliens, okay? You have domicile, you reside here. And Wong Kim also repeated over and over. It did so 7 times in the first paragraph and repeatedly after that. Domiciliaries. Now you remind us, don't go beyond the case and don't look at things that are irrelevant, but you just did that. It is not surprising that Wong Kim limited its holdings to domiciliaries. The court had little reason to consider what rule would apply to a temporary visitor because they were actually lawful and permanent and domiciled. So the court was hardly likely to upset the consensus on this, given that that issue was irrelevant. Wong's parents were here. If Wong Kim were so simple in establishing that even temporary visitors could be citizens, that meaning was seemingly lost along the way. As a DOJ report in 1910 said, a dozen years after Wong Kim Ark had come out, it has never been held, and doubtful whether it ever will be, that the mere act of birthing a child on American soil to parents who were temporarily here will confer citizenship. The clause refers to jurisdiction. That does not mean jurisdiction to which the bodily form of the child is subject from the moment of birth. It's a larger jurisdiction, which is exercised over a domicile. Now, in the years following Wong Kim, the citizenship clause was generally understood as limited to children born of alien parents who are not temporary, but are permanent. Nothing in Wong Kim changed the consensus, doesn't apply to foreigners, doesn't apply to transients, doesn't apply because to people who have allegiance to the other nations, but now it does. And as for the remainder of the court's reasoning, much of it is self-defeating. To begin with, the court invokes Frederick Douglass's statement that the Constitution knows all the human inhabitants as the people, but temporary visitors are not inhabitants. So even looking at Frederick's own statement, they don't live here. Inhabitant means domicile. Nice. And as Frederick himself argued that blacks were citizens because they were not comparable to temporary visitors, they're not aliens, they're not exiles, they're not strangers, they were uniquely American. They owe equal allegiance to the same government, which of course the foreign invaders today do not. Likewise, the court invokes another statement from Attorney General Bates. But the court does not seem to be aware that this phrase corresponds to the rule of domicile. Prima facie citizen means evidence of domicile. It's evidence of something. What evidence is that? If a person's parents were domiciled abroad, then the prima facie case was overcome. And beyond these statements, then, the court mainly emphasizes that the children of temporary visitors owe at least a partial allegiance and are owed a partial protection from us. Yeah, we owe them a lot. Free healthcare, free housing, free food, free everything, extra due process premium, and more. That undisputed fact does not demonstrate that they were citizens. To the contrary, it says not subject to any foreign power instead of owing allegiance. Precisely because of that, it was a partial allegiance, and he did not want anyone to be mistaken on that matter. Now, finally, the court relies on general statements without recognizing those statements are also compatible with our interpretation. The clause indeed followed the pre-existing law, but the law was based on domicile, saying that children born here to foreign parents indeed were generally citizens, but that's because they were domiciled here. The citizenship did indeed almost always follow birthplace, but that is birthplace with domicile. Birthplace follows domicile. Now, the court's responses to my view also undermine its own. You criticize me for depending on the parent's status, not the child's status. But the court's view depends on the parent's status too. The court, for example, excludes from citizenship the children of representatives of foreign sovereigns or enemy invaders, which are the parents. Unless newborn babies are serving as international diplomats, the court's account thus turns on parents. And they're not obviously diplomats. They're toddlers. Along the same lines, the court asks why words appearing frequently in the executive order, like mother, father, lawful, temporary, or all absent. But again, if that is a problem, then it is one for the court's theory as well. After all, the court's exceptions for foreign representatives and Indians and invading enemies aren't in the clause either. So finally, the court says that domicile is a difficult concept. But domicile, of course, is not. It's a concept that's already widely used in both federal and state courts for jurisdiction, conflict of laws, and its meaning is generally uncontroverted. And the court's concept poses its own problems. The court never explains, for example, what happens when a child is born to a citizen and a diplomat, or to a citizen and a member of an invading army. Then what? So you also then suggest that my interpretation is not consistent with the Civil Rights Act and the not subject to any foreign power clause, because a foreign nation can purport to exercise power over its original citizens after they establish domicile. But your interpretation, John, does not even attempt to be consistent with the civil rights requirement, since the children of temporary visitors are clearly subject to foreign power for their homeland. And regardless, the court is wrong about domiciliaries remaining subject to the foreign power of the country at birth. Although their nation of origin might purport to exercise jurisdiction, the U.S. would not have to recognize that authority as lawful once they're domiciled here. And so ultimately, you denigrate me and the evidence in support of my position as scant. I just crushed you on the page count. I see it very differently, says Thomas. The court cites little evidence from the Reconstruction Congress that even wrote this thing, and its other 19th century evidence is slim in comparison. And as for the evidence in support of my position, it's substantial. It's like 100 pages. Representative Bingham, the architect of the amendment and the clause, would not apply the clause to the children of temporary visitors. Trumbull, the champion of the amendment, agreed. Howard, who introduced the clause, agreed. The congressman after congressman during the debates agreed. Congress in 1870 agreed. President Grant, his AG, agreed. His AG before that agreed. Supreme Court in 1873 agreed. State legislatures agreed. The executive branch decision makers over the course of decades agreed. John Miller, Thomas Cooley, a battery of other eminent scholars agreed, and even the great Justice John Marshall Harlan on 3 separate occasions agreed. And so once again, I am quite comfortable with the company that I keep, John. Now, before concluding here, I briefly address the argument that even if the order has at least some lawful applications consistent with the clause, it is not consistent with the statute, which is Kavanaugh's argument. The court gives no independent import to the statutory citizen provision Congress passed, and I wouldn't either. From 1866 until 1940, the statutory law, required that a person claiming citizenship based on birth be not subject to any foreign power. That language from the Civil Rights Act, like the language of the Citizenship Clause, required that if you are a person claiming citizenship, that you have a domicile here. So both the statute and the Constitution require domicile until at least 1940. Then the Nationality Act of 1940 codified the existing law by enacting the clause's text. By the early 1930s, the American law on nationality was expressed in a large number of provisions. Roosevelt designated a committee to examine this, and the act was the first attempt after the founding to codify this. So a codification of existing law does not change the law unless it does so clearly. And when legislatures consolidate their statutes into a large code, they often revise wording. But the same is true here. And so the citizenship provision that Congress passed codified the not subject to any foreign power. It's a requirement. And it did so by borrowing language from the Citizenship Clause. So by using that language, it tracked the clause. Congress did not clearly change the law. It would be surprising to discover that this is a substantive change and that it's invalid. So the 14th Amendment, he says, was enacted in the wake of the Civil War with one pervading purpose: equal citizenship for the freed slaves. It was enacted, as Harlan wrote, to secure to a race recently emancipated the civil rights of other citizens. And this court has time and time again denied Americans that promise. Shortly after the amendment, this court deprived black citizens of the right to peaceably assemble and to bear arms. Later in Plessy, the court held the subjugation of black citizens in state-coerced racial segregation, which they wanted. The Democratic Party wanted more separate but equal when they had the gerrymandering. When it had an opportunity to correct that profound error, it did so narrowly in Brown versus Board of Education. And it then used that very decision to justify busing American children to different schools. And until recently, this court continued selectively enforcing our colorblind Constitution by allowing state-coerced racial discrimination in public education and compelling states to draw political districts on the basis of race, separate but equal races in districts. Now, meanwhile, the court has repurposed the 14th Amendment to protect its own set of preferred rights that the reconstructed Congress never contemplated and that cannot find support in its text. So today, the court does that again by recognizing a constitutional right to citizenship for the children of all foreign birth tourists and illegal aliens in the Constitution. It is insane. It's going to take me a week to understand how they could do this to us. I am not sure today's opinion will stand the test of time. I hope he's right. The citizenship clause added greatly to the dignity and the glory of American citizenship, and now it means nothing. You can break the law, come in, dump out a baby, you're good. Today's opinion devalues that citizenship. I respectfully dissent, and they did it in a really gross fashion. They said, well, illegal alien foreign invaders are like black slaves, so it's all the same. Really. Denying America's history on that major formative event that is part of our entire development as a nation, it's all the same. So just throw it out the window. Disgusting behavior. So once again, going back to our chart, this is now a constitutional rule. So the EO is invalid under the Constitution. Congress is not going to be able to fix this at all. So Clarence Thomas is up here. Let's see where Gorsuch and Alito stand. We've got another 40 pages or so. And here is Alito. This is one of the most important decisions in the history of the court. Yeah. And in my judgment, the court has made a serious mistake. Thank you, Judge Alito. As interpreted by the court today, the 14th Amendment confers citizenship on virtually everyone who happens to be born in this country, including the children of birth tourists, women who come here solely for the purpose of giving birth to a child and then promptly leaving. Careful analysis of the text of the 14th and the process that led to its adoption shows that it does not degrade the concept of citizenship in this way. Instead, the 14th confers citizenship on only those who at birth owe allegiance solely to this country, and they don't. Respecting this interpretation would not require uprooting the millions of children who were born here to mothers who entered and remained in this country illegally. Those children are not responsible for their parents' violations of our immigration laws, and their plight is the result of a long period during which a coterie of actors, executive branch officials, states and cities, and a variety of private groups sent the message that would-be immigrants that our immigration laws should not be taken seriously. And this message, coupled with the ineffective or unenthusiastic enforcement, spurred massive illegal immigration and a growth of a large contingent of people who were born here to mothers unlawfully here. Some members of this group have lived here for years, and they have a strong moral claim to be able to remain in the land where they grew up. But Congress can and should address their situation. The 14th Amendment dictates who must be a citizen, but it does not address who may be a citizen by an act of Congress. Congress has conferred citizenship on many people who are not made citizens by the 14th, so they can expand the rule over the floor. These people and millions of immigrants who have been naturalized are no less American than those who are fortunate enough to be born here. So for these reasons, the 14th doesn't require inhumane results, and we shouldn't fear the consequences of rocking the boat here. Nor should we take the position that our hands are tied by dicta. Citizenship is precious. Anyone who's been to a naturalization proceeding understands that. And you, following British rule that's been modified many times during prior eras and making this binding, is incorrect. The Declaration repudiated the British rule. And that's the whole point of it. There's no evidence establishing that our references to citizenship was incorporated all the way through the Revolution, through the Civil War, and then finally codified in the 14th Amendment. And then dicta in Wong Kim Ark buttresses that. According to the court, the 14th Amendment and the Citizenship Clause codified the British rule of birthright citizenship with only one new exception, which was the Indians. This is a curious claim, and it is ironic that the court should embrace this only days before we celebrate our 250th anniversary of the Declaration of Independence, when we emphatically renounce that. That rule wasn't about citizenship. There weren't citizens back then. It was about a feudal relationship to the king. And the king sits on God's throne. And the theory of monarchical power and the status of the people at the foundation rejected that. In a system of soil and servitude, you say that being subjects is emancipation? Our founders disagreed. The Declaration emphatically rejected that. It proclaimed that governments get their people from the governed. It's not a divine right. And so with your foundation blown away, the British rule of birthright subjecthood was not easily incorporated. We had slavery, we had race, and just 4 years before the colonies declared independence, there was another decision that said slavery had any common law foundation. So even for the free black population of the United States, there was substantial opposition to the British rule. And the second problem was the status of the Indians. And under the clause of the Constitution, how do you allocate seats? The existence of these two big carve-outs refutes any argument that we were taking their rule. We said they're not included. In Britain, birthright subjecthood was part of the common law. Why would that have a similar status here? Alternatively, did the rule have some status under federal law? So in this case, because we are concerned with the meaning of citizenship, it is the second alternative that is important. They go back to Lynch, which Clarence Thomas talked a lot about. But we also have the presidential eligibility clause, which requires a president to be citizen at birth. No case about the meaning of the term citizen reached the Supreme Court until Dred Scott. And before then, the British rule did figure in a handful of antebellum decisions, but none of these addressed the constitutional question. And the question of citizenship regularly came up in cases in which the jurisdiction of a court was invoked based on diversity of jurisdiction, who can sue and where. And adverse parties could show that they are citizens in various states. And in the years before the Civil War, and indeed until many years thereafter, the distinction between citizens and aliens meant even less than it does today. So whatever the reasons, citizenship came back up. The important point for today is that during this period, there was no settled understanding about the meaning of citizenship under the Constitution. Then after the Civil War, Congress faced many black challenges with black Americans and the newly freed slaves. In tackling that question, the court started carefully examining the text of the Citizenship Clause. Clause says, as we saw, subject to the jurisdiction thereof. two components, born in the U.S. and subject to the jurisdiction thereof. And that is no easy task to ascertain what that phrase means. We have to apply it here. It's a term of art. And how do you interpret it? If the clause set out specifically named exceptions, but the citizenship clause was framed differently, it sets out a general rule not conferred upon a person if they're born here unless they're also subject to the jurisdiction. And by its term, that rule applies across the board. So what does it mean to be subject to the jurisdiction? Doesn't explain it in the amendment. So subject means within. Does it mean within or does it mean subject to? We have to look to the text. He goes back, just like Clarence Thomas did, goes into the debates. One of the chief reasons for this. So at minimum, the text needed to be at least as generous as the Civil Rights Act counterpart. You know, there's overlap. The Civil Rights said not subject to any foreign power. So if they're parallels, they should be, overlapping in their definition. Now that language preserved two exceptions that are well known at the time, Indians and the other exceptions. He walks us through those. Diplomats. There's another exception here, children of foreign diplomats. And so the children of diplomats are also excluded. We saw that as well. So a lot of this I think, is duplicative arguments. But ultimately, in sum, the 14th Amendment confers citizenship on a person who is born in the country and naturalized and not subject to any foreign power. We got to use its plain meaning. The majority is deviating from the plain meaning. They're saying it's now geography. It really has no allegiance component at all. And so they fail to even comply with the text of the law. But they don't confront these problems. They do their own analysis. They cite these other cases. Thomas went through all of that. They go through a schooner exchange case. Thomas went through a lot of that. And so the interpretation now doesn't even depend on the debates. Trumbull talked about it. What do we mean? Thomas said this too. Not owing allegiance to anybody else. That's what it means. Other senators agreed. Again, Thomas talked a lot about that. Now, I don't think that we should base our decision on their statements, but he says we should base our decision on the text, and the text is very clear. Then we ratified it and continued with some of the exclusions. The court leans heavily on Wong Kim Ark. Clarence Thomas obliterated that one. All throughout that decision and relied on the dicta. Clarence Thomas handled that argument. And so the court dismisses those points, doesn't want to even talk about domicile at all. And when we understand what happened in Wong Kim Ark, it's domicile. And so it's best understood as people who are lawfully here, not illegal aliens without lawful status. That was for Chinese immigrants, as we know. And now this has become a massive problem. After the 1970s, we've now got 290,000 people here on visas. Many immigrants stay in the country illegally. American employees were willing to hire them. As a result, illegal and illegal immigration soared. It was negligible in 1960. Now it's huge portions of the country. Early efforts to solve this problem floundered and failed. In 1986, more than 20 years after passage of a major bill, Congress decided to do something about it. Harsher plans on how to deal with it. Then 2.7 million illegals got legal status, but it didn't solve the problem. And Congress has not passed comprehensive immigration reform at all. And when Congress failed to do this, states stepped in. On illegal immigration, as it continued to climb, states tried to lessen the effects. Arizona tried to revoke business licenses, but they were not able to do that. Following this victory, states worked to ameliorate the problem as well. Arizona went further to punish illegal immigrants for working or failing to register. A lot of litigation has been going on amongst the states. The federal government sued under Biden to stop Texas from doing anything to stop illegal immigration. Texas erected a barbed wire fence. Lower court said can't do that. So we had 10,000 Haitians filling up the bridges. And it's been a massive, massive problem. So Congress and their failure to act and the executive branch's enforcement policies have resulted in a massive number of illegal immigrants living in the country, growing by 2 million people in 22 and 23. Some estimates saying 9% of all births in 23 were to mothers who were here illegally or temporarily. These numbers are striking. And after 23, the trend appears to have intensified. Between 23 and 24, the overall foreign-born population increased from 48.5 million to 51.6 million. 3 million immigrants in 9 months. Why? Joe Biden let them in. Look at that number. Look at that. As a result of these events, the U.S. now has a huge contingent of people here illegally. And now the 14th Amendment makes all their kids citizens. And so, as we know, it means subject to the jurisdiction thereof, not subject to any foreign power. And Mexico is at the top of the list. A child of a Mexican parent can become a Mexican national at birth. Guatemala is also on the list, meaning they are actually subject to a foreign power. They're born here, they're made nationals, and so they're still subject to foreign powers. And so the court's interpretation is contrary to the original meaning of the 14th Amendment. It produces grotesque results. While foreigners who wish to immigrate lawfully must sometimes wait for many years, a child born here to a birth tourist is automatically a citizen. This also has national security implications. Suppose that a person's only connection to this country is that he was born here to a mother, was present long enough to give birth, turns around, goes back to China. Suppose the child never visited the United States while growing up and was inculcated with the hatred of this country. According to the court, that person's a citizen. He can come and go, get a passport, he can plot to harm the country, and has all the same privileges and benefits as another American. So if the 14th Amendment required these results, the Constitution would have to live with them or amend the Constitution. The country would have to live with them. But the 14th Amendment doesn't. And so in my judgment, this court has made a mistake that will seriously affect the country's future. And for that reason, I respectfully dissent. And man, he's right. So we're in big trouble. And then lastly, from Gorsuch, at the heart of today's disputes are two competing views. One, English jus soli, the right of the soil, based on the notion that a man owed fealty to the king. On the other is America, full dignity and glory of American citizenship. Now, to my eye, the latter understanding matches the clause. I just want to emphasize a few points. First, the understanding Thomas and I share of citizenship is consistent with Wong Kim Ark. Those parents were lawfully here. The question the court faced was whether he was a citizen, and this court rejected the government's position that it needs to go from citizen to citizen in order to pass. But what matters if they were domiciled. And second, the respondents chose to pursue a facial challenge to the order and secure the preliminary injunction. But we can sustain that injunction only if no set of circumstances could be applied lawfully. Now, that is a demanding standard. That's not met here. Among other things, the order holds that children born to temporary visitors are not citizens. And at least to that extent, the order is consistent with what Thomas said. So by definition, temporary visitors who don't make a permanent home here cannot claim the privilege of citizen because the order is lawful, at least to that. The challenge must fail. And so Gorsuch, once again, saying that it is at least partially lawful. Now, I think he would split it between illegal aliens residing here and the birth tourism people. But ultimately, I would put him in this box over here. And so it's a 6-3 decision. Kavanaugh doesn't do much to save us. It would have been a much better decision if we would have just had somebody over here, right? Because then you could at least make the argument that you could challenge it in Congress. But all said and done, that's the decision. It's about 194 pages, and it's not good, man. Like, no way to sugarcoat that. 6-3. Here, you've got the 5 with a plurality that say it's a constitutional win. Okay, so you can take Kavanaugh out of that. You want to look at this nicely and subtract Kavanaugh. Call it a 5-1-3 if you want to. But the 5 still is saying, they are saying that this is a constitutional underpinning. And if you want to change it, you got to amend the Constitution, or you got to change the Supreme Court, and they have to come back out and reverse themselves. So it's a major loss. Yeah, it's a major loss, unfortunately. Now, friends, let's see what you have to say about all of this. We may want to pause on the other cases and just come back on those later. But we could just read the head notes on the other ones. But very irritating. Let's see what you say about all of this and more. It's a terrible Tuesday. Thank you, SCOTUS, for nothing. We got some comments here that have come in. And let's see, are you seeing any other reaction that's disagreeing with anything that we just shared? Let's see. Man, lots of comments. Thank you guys for these. And these all came in today. Yeah, has Trump posted about this at all or said anything? Let's take a look. Not. Yeah, he did 56 minutes ago. Trump posting this. The Supreme Court upheld birthright citizenship, which is too bad for our country, but we can easily make it up in Congress through legislation with the support of the president that has now been determined during this process. No long and unwieldy constitutional amendment is necessary. I don't know. Congress should start today to work on ending expensive and unfair to our country birthright citizenship. They will have my complete and total support. President Trump signing off on that one. So, I mean, they could, you can, the boat, if you're on the boat, we're in big trouble, right? If you're in the boat, then you can have a baby. The baby stays on the boat as a citizen. But the goal is don't let anybody else on the boat. Okay, so if you're pregnant and coming in, Congress can prevent that from happening. Like, we can articulate and limit visas. We should be able to prohibit, and control immigration into the country. Birthright citizenship is a separate concept. So we got to control immigration. We got to really accelerate the deportations. But otherwise, if you're here and if you have a baby, the 14th Amendment says that baby is a citizen based on the geography, based on the location of the baby. So that's what Trump has to say. I'm wondering if there's any other, immediate reactions from on X. Let's take a look. Anybody commenting on this? Mike Johnson is here. Let's take a look at what he just said. That wasn't Mike Johnson. Here's Mike Johnson. Over on C-SPAN, he got asked about it. Presumably has not read this yet. Here's Johnson.
The last case is not presented, but do you agree?
Birthright citizenship. Yeah, okay, look, yes, as a constitutional lawyer, I got lots of opinions on this. Okay, understand what the framers did, and when we added this to our constitutional order, I understood what the intent was. I think anybody who looks at this. Oh dear.
That decision is children born in the United States, parents unlawfully or temporarily present, are subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment Citizenship Clause. What's your reaction to that, Mr. Speaker?
Well, I need to read the opinion, okay? But obviously that's, I mean, you could say that's a textualist, originalist view. However, I do think that this has been grossly abused in recent years, okay? And that is the case that was being made by the plaintiffs in the case, and we're very sympathetic to that because it is a serious problem. We have it's become a tourism, birthing tourism, they call it, a trend where people will just come and you just come onto the soil and have your child, and then they're able to avail themselves of the welfare state and everything else. It's been abused. It's one of those things that was intended to serve a noble and important purpose, and has been thwarted and overused and abused. And so I'm sure that we'll continue to look at that. I mean, I'm sure the conclusion from this opinion is going to be that you got to amend the Constitution to fix that.
Yep.
As we all know, it's a big challenge to amend the Constitution. It's only happened 27 times in our whole nation's history. And the reason is because you got to have 2/3 of both chambers of Congress and 3/4 of the states to ratify. It's usually at least a many years long process and very complicated. We'll see. I'm sure there's going to be lots of discussion about that. I will say I'm very disappointed in that outcome. I think it subjects the country to serious challenges going forward, and we'll have to deal with it as a Congress.
All right, so that's what they've got. Let's see what, I think I had a Fox News clip here. Let's see how they broke it down. And then we'll get into your comments.
And it's a big one. It has to do with birthright citizenship. It was an executive order that President Trump, on day one of his second term in January 2025, signed the executive order. It was immediately challenged, and now we can tell you that the U.S. Supreme Court has ruled against President Trump's order to limit birthright citizenship. Shannon, we have talked for some time about the president feeling that he would not win on this one. The question is, why not?
Okay. Right off the bat, it says children born in the United States to parents unlawfully or temporarily present are, quote, subject to the jurisdiction of the United States and are citizens at birth under the 14th Amendment's Citizenship Clause. Let's look how this broke down. As we expected, the Chief Justice wrote this opinion. Justices Sotomayor, Kagan, Barrett, and Jackson joined. Jackson has a concurring opinion in which Sotomayor joins. Justice Kavanaugh files an opinion concurring in the judgment and dissenting in part. The dissent comes from Justice Thomas. He is joined by Gorsuch, Alito, and then Justice Gorsuch apparently has his own dissenting opinion. So
Not good. Not good at all. All right, let's see what you say about it and see who's joining us on the day. We had Dan, thank you for that one. Remember, with the proposed treatment of all ballot packets, they are to be scanned and tracked throughout the entire process, from Dan. Thank you, Dan. And just because a cat has her kittens in the oven doesn't make them biscuits, now does it? No, it doesn't. That's a good one for John Roberts. Ruby Hoove, thank you for bringing in Marge as a new member. Ruby Hoove and Marge, great to see you. Ruby Hoove says, God bless America. Like, subscribe, and share. Yeah, rough day. Biology always wins. What's up? Amy Anna, analyst in the house. Thank you, Biology, for bringing in 5 new membos. Bob Tubed. We got Sir Jax, Bugger, and a Freak all joining us as membos. Great to see everybody. Thank you, Biology always wins, for bringing them in. Economath says birthright will be last. Opinions announced from most June authors for the court to most senior. And since the most senior in the major assigns the author, the Chief Justice will take birthright. Yep. And that's what we saw. The final decision and the worst decision didn't even give us an out. Like, we could have had a Kavanaugh decision or somebody more in alignment with Kavanaugh, but nope, it's the Constitution. Hey, retired 5-0, man, thank you for being here for 1 full year. 1 year already. Love you back. Thanks for 12 months of tremendous fun. Not a great anniversary present, though. Shiloh, 9 months. That's a full baby. Shiloh 420 in the house. Thank you, Shiloh. Thanks for being a member for so long. We appreciate you being here. Sand Crab News. Yeah, 18 U.S. Code 1401 C to H are born outside the U.S., requiring qualifications under 8 U.S. Code 1431A for naturalization. Yeah, and we were kind of hoping that they would be able to refer over to that Like the jurisdiction can be set by Congress. And even if we lose, we would be in this bucket where Kavanaugh is, but we're not. We're down over here. So Congress can, that's the floor. Like Congress can lift that. I think Congress can say, well, this counts as that. But if you're here, the president cannot limit that. Like the Supreme Court just gave us a really crappy low floor. So thank you for that. Sand Crab News. Hey, Tattoo NMD. Good to see you. 6 months as a membo. Almost a baby. 3 more to go. Happy 250th, everybody, with this big crap sandwich delivered for our anniversary present courtesy of John Roberts. Hey, be controversial always. I cannot believe we needed the Supreme Court to say female sports are for females. This is embarrassing for the nation as a whole. Yeah, that's the silver lining. I mean, we had 2 other decisions. One, the NRSC wins. In other words, they can continue to spend money. Okay. Then we also have the trans cases where looks like those were like almost unanimous, 9-0. Otherwise, they were 6-3 as to the logic. But men in women's sports, no. So those are good decisions, but just not even remotely even close on the scale to what we're talking about with Birthright. But thank you, Be Controversial. I agree. Sand Crab, thank you for that one. Mitchell Ryan, while I'm disappointed in the voting ruling, this just means we have to play their game in order to win. Yeah, we have to deport aggressively. It's like, you got to go. Like if you're a non-citizen, you just have to go. I think immigration should just largely be cut off in general. No more, we're full. We got invaded for the last 4 years. We're good. We got like 50 years of immigration. We squeezed that into 4 years under Joe Biden. We don't need any more. And other like really aggressive measures, cut off, no benefits, TPS, like all the Haitians got to go. TPS canceled across the board. Yeah. So you really got to play. CJ, what's up? We don't have a country, man. No, it's kind of now for foreign invaders. You can just literally break the law, come in, and it's your country now. And once they have a child, the likelihood that they get deported with a citizen child goes to basically 0. I know you hear the DHS come out and say, well, they can go back as a family. Doesn't happen. CJ, it's true. We got screwed. Hey, Taco Woman, Sandy Ravage. We're so screwed. This was a big one. Yeah, this was a really big one. It sucks. Not a good day. Not happy. Vrooman, yesterday the court went insane. Our elections are silly, and today that insanity held. Citizenship means nothing. We are not protected from invasion, but I can't speak Chinese. Oh no. From Vrooman. Yeah, and the libs got exactly what they wanted. It's constitutional, man. So the likelihood of undoing that is extremely low. And we have, I've heard Greg Bovino say he thinks it's like 100 million. And all the visa overstays, you can come here on a visa, have a baby, it counts. It's just like the hollowing out of America. It's not good. Thank you, Varuman. Hey, salute or surrender. It's not as bad as we think. Trump is doing mass deportation, so we have a little time to fix this. I just don't know that you can get them out. Let's say there's 20 million people. That means you're doing, 7 million people over, for the remaining 3 years, let's say. It's more like, 9. If you got to get to 20, how many have we deported already? So like 9 million a year. The scale to get them out is so dramatic, and they know that. That's the whole point. It's the whole point. Thank you, salute or surrender for the dono. Hey, Bill Dozer. Good job on Trump, Amy Coney Barrett. Good job, Trump, on Amy Coney Barrett. Bad decision to put her in over actual constitutionalists. Hope he doesn't listen to the Federalist Society if he gets to appoint another justice. But he does like the establishment. Yeah, you know who picked some good judges? Bush. For real. We got Alito out of that one. And did he put... No, he didn't appoint a Clarence Thomas, did he? Who appointed Clarence Thomas? Was that Reagan? So anyways, thank you, Bill Dozer. Mark, what's up? Mark Vell. Hey, according to the National Archives, there is a comma. Yeah, and can you believe this crap? In the middle of a Supreme Court decision, they don't even comment with a comma appropriately in the opening paragraph. The whole thing's insane. Comma is missing right there. I'm not making it up. There's a comma. In the United States, comma, and subject to the jurisdiction thereof. They can't even get that right. Thank you, Mark. Hey, we are now USA and subject to the jurisdiction of China. ... No comma. It's like a total free-for-all. Congress, I think, could do something about the birth tourism thing. Just pull all the visas and tighten immigration on those rules. But are they going to? It's wild, man. Bad day. Yehuda, hey, are we now separating kids from illegal parents? I don't think so. I mean, they say that they are, but I don't think so. Like, they're not going to deport a parent with a 5-year-old citizen here and just say, send them going back. Oh, yeah, Papa Bush appointed Clarence Thomas. So the Bushes, they picked good justices. Is that right? Thanks for looking it up. Yeah, so it just, they're anchor babies for a reason. That's the whole point. Sandy, we need a law passed that foreign women who deliver a baby here are guilty of child endangerment. They serve 20 years and the baby gets adopted out to an American. Something like that. Yeah, that's tough. We got to go hard. We got to go max, man. We got to play for keeps. Hey, just John Doe. Ridiculous decision. So basically, we need to completely lock down the border, ban pregnant women from traveling to the USA for work or vacation. You can't fly in if you're pregnant. True. Yeah. And mass deportations. All benefits should be cut off. So there's self-deportations, no free housing. Any state that is a sanctuary state needs to be cut off of all federal funds. And this population leaves. They can't afford to be here. They leave, go have their babies back home. Steel Manning, otherwise, just to be clear, like in a couple generations, it's basically game over. And I hate this, I hate to be so black pill about it, but it's true. Because you're going to have illegal alien adjacent people. So you're going to have citizen kids with illegal alien parents. And they're going to vote the Democratic Party in perpetuity. So, Steel Manning, notice all Roberts' rationale is from before the 14th Amendment was passed. No analysis so far on the actual 14th Amendment. Right. He's saying that anything that came after the 14th Amendment is revisionist, and they're trying to remodify what came before. And we're saying the 14th Amendment was a shift from what came before. The 14th Amendment, was anchoring in a new concept that was not the prior rule from England. John, thank you, Steel Manning. Sandy, if the mother comes on a tourist visa and lies about the purpose, can the baby be denaturalized? No need to lie anymore, though. I don't think the baby's naturalized. The baby's a citizen by birth. Like, naturalization is the process by which you apply to become a citizen. You go through, you do your fill out your forms. I'm not a communist, whatever. So you can denaturalize somebody who is fraudulent in that process, but a baby's just a citizen. Just boom, there you go. Bill Dozer, we need to make Clarence Thomas robots and clones and replace the dummies on the bench. It's the only solution. Oh, I know, man. I think there's a good meme about that. Let me see if I have that real quickly. And then we'll take a look. Did I record this down? Scrolling. Oh man, I may not have saved that. But yeah, Clarence Thomas is the man. We could use a lot more Clarence. We get a lot better decisions than we've got now. All right, so Bill Dozer, thank you. Randy Brandel, I can't type what's actually on my minds without being visited by black SUVs. So I'm just going to say, great show, Rob. Yeah, I mean, it's a depressing one. Not a good day. But at least we got to understand the concept. It's arguably 5-4, arguably. So if you got to replace another judge on the other side, but Amy Coney Barrett's brand new. She's not going anywhere. Roberts has a long time ahead, so he's not going anywhere. 3 leftists are all pretty young. They're not going anywhere. So, hey, Cliff Meggs, is a new American amendment required? Yeah, it would be to fix this. In Singapore, a child born in Singapore after 63 is a citizen by birth only if at least one parent is a citizen. Yeah, that's right. And that's how it is in most places around the world. Other than in the West, a lot of the South American and Central American countries still have jus soli, but most other countries have just jus sanguinis, which is birth by blood. So a parent is a citizen. One of the parents is a citizen and it passes on to you, which is the much, much better rule. Quirinius, U.S. Citizenship Guide, get pregnant in 6 months, go on holiday to New York City, overstay your visa, pop the baby, self-deport, get a free ticket, then apply as a parent of a citizen. Exactly right. Exactly right. It's ripe for exploitation. You got to do something to stop the bleeding. Thank you, Quirinius. Hey, Spuds, Rob, does this cover a child born or conceived? If life starts at conception, then anchor babies are SOL. Wouldn't this make the leftists defend pro-life cases? It's the physical dropping of the baby. So when the baby is plopped on out, boom, American citizen automatically across the board. Quirinius, time to open birthing tourism company. Who's in? A lot of people in Miami doing that. Yeah, it's probably, if you're okay, kind of being a treasonous to your country and having foreign invaders come in, it'd be a good business model to get into. Steve Soto, what's up? Unless or until Congress cuts that off, like they should say no more visas for pregnant people, just period, end of story, because our stupid Supreme Court. And I hope Trump comes back down and does something aggressive just to say, eat it, Supreme Court. Steve Soto, Trump needs to pass all legal immigration, period, or pause all legal immigration, period. I couldn't agree more. Yeah, you want to have a free-for-all in the internals of America? Then we're not doing immigration. Just going to cut it off. We're not going to create an environment where you can come in and exploit the entire system. Commander John, what's up? SCOTUS is wrong. Sorry. No reason to be wrong. Sorry about that. They're wrong. Clarence Thomas just beat the crap out of John Roberts in terms of case precedent. His argument is resoundingly better than John Roberts was. Clarence Thomas is referencing back American history. John Roberts referencing English history. One makes sense, the other doesn't. One is being exploited, the other doesn't. The context of our current time matches the interpretation of the 1860s. But they just didn't even address that stuff. Hey, job for 9. Rob, I have to ask, is there anything that can be done about birthright? No. I mean, amend the Constitution or change the Supreme Court. That's it. Can it be presented again with another approach to the argument? Not unless it can come back, but the Supreme Court has already found this is the rule. So they would have to override the rule. And they'd have to override themselves. So I doubt it's going to happen in our lifetime, if ever. So we could amend the Constitution. As Americans, we could actually amend the Constitution. People could get so sick of this crap that we just say, not anymore. We're not going to do this anymore. Most other European countries and Western nations don't have this type of birthright citizenship. We're one of the only nations in the world. I think the only modern nation in the world that actually does it. Congress can't pass anything because a congressional statute can't override the constitutional rule. We have to have an amendment. An amendment can only be modified with an amendment, not a congressional statute. So start working on an amendment would be the only other solution. Hey, David Thompson, thank you, David, for bringing in a new membo. One new membo coming in the house, courtesy of David. Taco Woman, Sandy Ravage. Ignore the ruling. Yeah, the states are going to be having babies at the hospital, and the states are going to be processing the babies, and then the federal government will have to interface with the states. So I'm not sure this is one of those that he can, actually effectuate that across all 50 states. Many states will be gung-ho about this. Perfect. Even if he wanted to ignore it, I'm not sure he could. Laura, I wonder if the fact that John Roberts adopted Asian children affected his judgment. Yeah, and I think I saw that Amy Coney Barrett has some adopted kids, Again, that shouldn't have anything to do with this, other than maybe they've got some interest in, I mean, those kids should be citizens, presumably, and they're citizens and they're domiciled here. But yeah, you don't know. You don't know. And I think Clarence Thomas's point about dual allegiances is a pertinent one. Thank you for the comment, Laura. Michelle Parsons, Rob, how can the birthright ruling stand with TPS individuals since they are only here temporarily according to U.S. law? Doesn't matter. That was the Supreme Court rule. If they're here even temporarily, they count. This is totally antithetical to our legal doctrine. It includes everybody. You can be here for 5 minutes. You're here. Because subject to the jurisdiction thereof literally just means geographic region of control. That's it. So they count. Temporary, not temporary, illegal, not illegal, whatever. TPSers, all those 300,000, 600,000 Haitians, every one of their babies is now a citizen. Sharon Cole, what's going on, Sharon Cole? Thank you for the dono. Sharpening Man, mine and your kids are hosed, Rob. What to do now? We got to stay, we got to stay engaged. Like, we've got one country. There's nowhere for us to go. So, maybe the silver lining is people start to really see this. Maybe there's, maybe like red states become sanctuary states for citizens. And we say, we're not going to honor illegal aliens. And the federal government loses power or something, or chooses not to enforce against the red states. Like, if the federal government can't enforce the law against blue states that are sanctuary cities that are handling their own immigration procedures, why can't red states do the same thing? But now we're getting close to like a civil war, which I would prefer not to have, but yeah, it's not good. Joe, I'm officially black-pilled. No one is coming to save us. What do you think the next 5, 10, 20, 50 years looks like? I'd like to hear your predictions. Well, it's going to be a lot less American, that's for sure. It's going to be, I think, a lot of people with foreign interests who are in the country with foreign flags, who care about their homelands more than they do America. And so the ideas of, American values, things like free speech, the Bill of Rights, governments being a charter of limited powers, are going to start to reverse themselves. Okay. Many other countries, many other cultures, many other nation states don't care about those things. They don't really care about free speech. They want people to be brought to heel. They don't care about the Second Amendment. They don't really care if government is overpowering. If they cared about those things, you would see evidence of that in their home countries. You would see indicia that those values are important to them and they would be codified in their home countries. But that's not how they are here. I think that, at some point, we might have like 50 years. I don't know. I think you might start to see like a soft breakup or a soft breakaway, depending on how bad it gets, because we're already seeing, and I don't want that to happen, just to be clear, but we're already seeing the hints of that. If you have no faith in the elections, and if citizenship really means nothing, then what is the thing binding the country together? I don't know. I really don't know what it is. What is it? Sports? Is it gambling? Is it all the pornography or whatever? Like, what is it actually binding the country together? Nobody trusts the elections. You've got various states, like Minnesota turns into Somalia. New York turns into Islamabad, right? You have these things happening. There's going to be a reaction to that. And I think the opposite side will also start to congregate into various states. And if the elections don't count, then the money's being inflated, I think people might wake up and say, why am I paying taxes? Why am I still in this system? My vote doesn't count. Our country is being invaded by our so-called government that's supposed to protect us. So what's the point of even staying in the system? People will just start to eject out of the system because you get more benefits maybe on the outside than on the inside, where you're paying 50% of your livelihood back to the federal government that doesn't care about you or uphold your values. So Yeah, and what are you going to do? Just keep voting? Press the dummy button? Like it does anything? So I think, maybe you really start to see a separation. We're already seeing that. We already have sanctuary states that are mostly serving the interest of the constituency, the newly arrived constituency, versus the people. And it's not good, man. It's not good. I hope it doesn't happen. Michelle, I can see it happening now. A total ban on any pregnant women traveling to the U.S. SCOTUS is truly opened a big can of worms. We'll see what Mark Wayne Mullen does. We'll see what Trump does in response. I think that's a good place to start, but it doesn't address, that's a small fraction of the 20 million people who are here already having babies. So Arc Dragon, Congress needs to pass a law stating any current non-citizen or future-born individual whose parents are not current citizens are not subject to our jurisdiction, except that of deportation. Yeah, I mean, it's a good idea, Arc Dragon. The issue is that the Constitution is the floor. You can't drop below that with a congressional act. So if you're here geographically and you drop a baby, that's a citizen. Congress can't lower the bar on that without an amendment. So, E-Texley, good to see you. Hey, imagine this. The U.S. begins drafting citizens into military service to fight against an Islamic state. Does the U.S. exempt Muslims who are U.S. citizens from military service? Or does the U.S. conscript those persons, arm them, train them, and give them classified info? And would they be loyal to America? Certain people who've come from foreign lands who are dual citizens, are they loyal to Americans? I'm not talking about like American Muslims. I'm talking about people who come from foreign countries who then get essentially citizenized, either themselves individually or their kids. And like, if you conscripted the Somalis in Minnesota to go fight war against Somalia, do you think that they would do that? I don't. What about babies born in the U.S. to parents who hold Sharia law superior to U.S. laws? Does that not mean that Muslims do not recognize themselves and their babies to be subject to the jurisdiction of the U.S.? Again, none of that matters. Allegiance, loyalty, it's not the rule. It's now geography. You're here, you can get in the building, you're good. Chat with me. Did the Supreme Court just give the U.S. permission to send home invading alien parents while keeping their citizen children in the States? Yeah, I mean, you can deport people. You can end TPS status. You can do these things. But then you have the consequence of having a child here that becomes a ward of the state. And parents go home. So I think they're less inclined to do that. Hey, See the Veil, good to see you. Have a great morning and a great day. Thank you, See the Veil. Thanks for the positivity. Hey, what's going on? Rubos. Thank you, Rubos. Rand Paul filed this on the 29th of, April, saying a joint resolution proposing an amendment to the Constitution. Thank you, Rand Paul. We all should get behind those efforts. But then, it's got to pass an insurmountable hurdle, including 3/4 of all states. And many states are filled with illegal aliens and illegal alien adjacent people who definitely are not going to want to sign on to the amendment, which is why I think it's a tough one. Hey, Debs, thank you for the read. Kept me awake on my drive to DC. Amazing. Debs Wish, any good pizza recommendations in DC? Yeah, we the Pizza. We the Pizza is a good spot. And I think there might be a couple locations, but it's good. Ask for the big pepperoni. Sometimes they give you these little pepperonis. They're for weaklings. So Debs Wish, have a great time in DC. How fun is that? Maybe we'll see you out and about. Have safe travels. And it's going to be fun here. Gene Moore, SCOTUS rule multiculturalism over assimilation. Yeah, I mean, it's really kind of not either of those. It's like, it doesn't even matter what multiculturalism. It's just like a total free-for-all. You're here, you have a child, even if it's like worse than multiculturalism. It's like you could be a Chinese person, drops a baby, gets a citizen, takes the baby home. So you're not even in the system, but you've now got the benefit of American citizenship. It's like wild, man. Be controversial always. Clarence Thomas is an absolute judicial unit, man. He just kept going and going. We're glad that he did. Got to mark that record down. Thank you, Be Controversial. Jason Madruga. Rob G would make a better than the Supreme Court justices who voted for birthright citizenship. Yeah, man, we would have been pretty good on these last cases. We would have been, election day is election day. We would have said birthright citizenship means domicile, allegiance, subject to. And I think we could have done a better job than John Roberts today on this one. Thank you, Jason Madruga. And we wouldn't have felt compelled to make everybody happy or not anger all the foreign invaders. Thank you, Jason. Steph D, hey, so disappointed we're about to lose our country. Yeah, it's not good. It's not good. Normally I like to be positive. Oh, we're going to fight, whatever. It's not good. And it would have been even if it was in the second bucket, it would have been disappointing, but not the end of the game. It's pretty bad. Cat, we all just get along. Hey, 41 months is a membo. Next step, constitutional amendment. But I think in lieu of that, we're going to have mass deportations, very strict immigration, and that's for the foreseeable future. Thank you, Cat. We all just get along. Hey, Henry Sir Edward Coke. His surname is pronounced Cook. Well, he's a loser, and I don't appreciate his jurisprudence making its way into our country's birthright. So screw him. But thank you, Economath, for the pronunciation. Hey, Nathan Butler fighting the fall. Domicile is an individual's permanent fixed home and legal residence. Anyone without a citizen or naturalized parent who does not have a lawful permanent residence in the U.S. is not a citizen per the Constitution. They are now. Yeah, I agree with your preferred interpretation, but they are now. You can be here for 5 friggin' minutes and drop a baby. Baby is a citizen. Really no limitations except for a couple categories, which won't apply to the vast majority of the cases that we're talking about. Hey, Charisse, thank you for the dono. You're amazing. Harlan Audley Jones, you're amazing. Thank you for becoming a supporter. Great to have you here. Can Trump bar pregnant women visas or travel to the U.S.? I would imagine. Yeah, I would imagine. I don't know the mechanics of that, but I'm sure they're working on it right now. So I would not be surprised if we see something along those lines. Yeah, Data. What's up, Data 12? This is an amazing reading of the Dissent of Thomas J. Yeah, he's really good. Yeah, he's really good. Thank you for the dono, Data. Economath. Hey, briefly playing devil's advocate. What if Roberts and Barrett voted as they did, yet defended it so weakly in order to spur us to change the law? That's a really generous, gratuitous interpretation, Economath. I think that if they wanted a change in the law, then they would have been in the other bucket. They would have moved one over and joined Kavanaugh. But they didn't. Their decision makes it almost impossible to change this. So, almost impossible. Deconstruct. Hey, can we prevent or restrict pregnant women from entering, regardless of their reason for entry? If we see a birth is imminent, we should block entry. I agree, and I think there is probably a mechanism of doing that. Visa is more permissive. You just grant permission to certain groups of people that are beneficial in the American interest, but that's not the big category. Like the birth tourism thing is a big deal. The big category is the group of illegal aliens who are already here, probably to the tune of 20 million people, who are now all count. Right? That's the problem. Like we got invaded for the last 4 years, and so they're all here, all just pumping out babies. All of those count. So I think that's the bigger problem. But yeah, I mean, we should try every single thing. Like all the stops have to be pulled out. Nathan Butler, what's up? Trump should do what Dems wanted and add 4 new judges. That's another way to do it. I mean, that's another alternative. Pack the court like now. And the filibuster, pack the court, put on some conservatives, rehear the case, reverse it. It's another solution. GM Evil Smiles. Hey, just wanted to say thanks, Rob, for the breakdown. Thank you, GM Evil Smiles. Yeah. Thank you for being here. Thanks for joining us on a tough day. 14 months as a membo. Debbie O. Apparently, Alito's dissent outlines congressional action to overcome but I haven't been here to hear about it or read it myself yet. Well, I think his dissent was a lot of what we saw in Thomas's dissent, which is kind of why we flew through it. But it's also referencing all of the congressional underpinning that the actual real interpretation referenced. So things are at conflict. Nobody really interpreted it this way until the modern era, Clinton and FDR. But before that, it's an insane rule. Like, what kind of insane rule is this? But again, Congress can't override Congress. That's the whole point of Congress can't override the Constitution. It's just a hierarchy. Michelle, Rob, has a Supreme Court justice ever changed their opinion after their original opinion has been published? Is it legally permissible? No. I mean, once, like, they can change it in a different case, but they can't come back and reverse this one. I don't think that's ever happened. Like, actually, I changed my vote. I want to go back and modify my prior vote. This is done. If they want to revisit it in a later case, in a different permutation. But again, this is pretty broad. Like, it's pretty unequivocal. So I'm not sure you could try, Trump could change some words in the issue a new order, but the rule's pretty blanket and it's like based in at the foundation of the Constitution. So I think we're stuck. And why? Mike Johnson, he's a nice guy and a smart lawyer, constitutional lawyer, but the reason why there will be a civil war and I predict the union doesn't survive is because of people like him. He has been largely ineffective in controlling illegal immigration, and he is a big zero. Yeah, and I don't want the country to break apart, but if you have nothing in common, if you have people who think that us current Americans are living on stolen land, they're here siphoning off a bunch of resources. They have no interest in integrating at all. They create rules and benefits that favor them as opposed to the native the native citizens of America. And our elections don't matter. Then what's the point? Why are you paying into taxes to support this population? People are going to get tired of it when they can't afford homes and food and housing. And it's not going to take much, I think, for people to start ejecting out of the system. Baby Lewis, how could these judges, and by the way, that's our birthright, okay? It's in the Declaration. There comes a time when the tyrannies of the government call for the emergence of a new government. You know the language. How could these judges not think of our children and all of our grandkids from here on in? Well, I think in many ways they're kind of a bubble. They want to be part of a political class and they don't want to rock the institution. And they think, oh, it's always been this way. It's been this way for a long time, so we're not going to change anything. Which means they're siding with the foreigners over the Americans. And again, if your government is not serving you, what's the point? Hey, the taco vendor, is the republic all but lost? I mean, we're not it's not dead yet. It's not on the operating table and we're giving it the paddles, but it's getting pretty close. So we still got Trump for another 2.5 years. So at least, so we'll see, and then maybe, Vance or somebody else, but we're on the precipice. Like it's really, really close. And depending on how they go, we might be up there with the paddles. And why Birthright has been circulating as an idea and was probably presented way too early. People are not mad enough. Sadly enough, U.S. citizen blood and treasure hasn't been affected yet. I live in Southern California where the illegals march. They fly their own flags, not a U.S. flag. They're loud, proud, and will take what they want. 100%. And they're way more organized and aggressive than American citizens are. Many Americans just don't want to be called bigoted, so they don't want to comment about these things. They say, oh, diversity is like a strength when diversity just means anybody except you. Like, no, I support diversity. That means like killing you. No, that's not what it means. It means I get more Mexican food restaurants in my neighborhood. Okay, so they're coming to steal from you and to take your property and to take your taxes in the form of handouts and more, but you still support it, and they do because they're so brainwashed and brain dead. As they're literally marching around with their foreign flags. I don't know how many videos we've played of that, but it's true. So, hey, socialism sucks. Really weak men make really hard times. Facts. And the cycle continues. Thank you, socialism sucks. We got Rob. We are officially worse than a third world country. Well, we are going to become a third world country. Yeah, it's kind of the point. Because it's not like immigration is bringing in law-abiding, honorable people with integrity. They're breaking the law. When illegal immigration was happening under Joe Biden, they were coming in illegally. And then people like Kilmar were trafficking humans into the country illegally. So if they're going to behave that way in their home countries or in our country, then we're going to start to resemble their home countries. It's not good. Gloria, hey, thank you for bringing us the news, Rob. Thank you, Gloria B, for being here 39 months as a membo. Long time. We love you. We appreciate that. Rubos, hey, remember what God said? Yeah, give us a prayer, Rubos. When things don't go your way, he said this in 1 Peter, casting all your care upon him, for he careth for you. Be sober, be vigilant. Because your adversary, the devil, as a roaring lion, walketh about, seeking whom he may devour, whom resist steadfast in the faith, knowing that the same afflictions are accomplished in your brethren that are in the world. Cast thy burden upon the Lord, and he shall sustain thee. He shall never suffer the righteous to be moved. From the Rubos. Amazing. Rubos, thank you for the prayers. We need it for me and the country. Steve Briggs, send a bill to the foreign nations for $50 million for each child born on U.S. soil. Yeah, and then Trump says, well, we're going to tariff you as a penalty for not giving us good policies. And they take that away too. Biology always wins. Hey, rockin' Rob for president, man. That'd be good. I'd like to, fix a couple things. We're happy with Trump right now, of course, but, I've got some ideas. Just PS girl. Didn't 47 say 2 justices are compromised? I don't know. I don't know if they just wanted to form a union with the left in order to satiate their political goals, or if they believe this in their hearts, who knows? But whatever it is, it's a bad decision. Mad Million. Does this give us a view into DACA? I don't think so. I think that, if you're here on DACA, you can have a child and your child's a citizen. That's about the only extension. Thank you, Mad Million, for the dono. Joe, what is the next step? What do we do now? So again, I would say you got to stop the people coming in. You got to increase the people going out. Immigration policy needs to be as extreme as it essentially possibly can in order to return territorial integrity to the United States. I think that's what it was. And why? Rob, I am more black-pilled than you are on this topic. There is a major faction of the Republican Party pushing the Dignity Act to legitimize millions of people who are at their core are stealing and cheating to get ahead economically. Yeah, and Republicans are on board with that. Find the nice, quiet part of North America and protect your property. Don't expect the government to do a thing for you. Yeah, that might be a good idea. Get off the grid, find a nice red state that will be red for the foreseeable future and start to bundle up around that. Logically, Steve, how are people subject to the jurisdiction thereof if they are totally unknown to the government? Do we have a 6-3 liberal court? Yeah, it's a great question, right? If they're here illegally and they're in violation of the law and you don't really know where they are, how are they subject to the jurisdiction? It's because, in theory, the thesis is that they're in the geography, which means it's just a territorial limit, essentially. Thank you, Steve. 51K, we're one step closer to owning nothing and being told we're happy. This destroys any remaining sovereignty we had. Freedom doesn't exist without sovereignty. Removing it brings the globalist goal much closer than it was yesterday. Yeah, and citizenship is critically important, right? It should be something that is cherished and revered, not something that is handed to people who break the law and scoff at the nation state's sovereignty. No other sane nation, just look them up, around the world does this at all. So it's a shame. Data, pretty sure a foreign pregnant woman must be mailed her ballot before she comes to the USA to birth 100 days after the election. There we go, Data. Thank you for the fun joke. Yeah, maybe we can mail them their ballots too before they get on the airplane from China to come with an anchor baby. Hey, Taco Woman Randy Savage, Trump should threaten to stack the Supreme Court. Yeah, maybe he will. And Trump said this: I would like to congratulate President Xi and the great country of China on their massive birthright citizenship win. Great. Trump kind of introducing some levity on a terrible loss. But it's true. Congratulations to China, the Supreme Court of the United Chinese States. The Supreme Court of the People's Republic of China acting today. Great job. Sandy, John Roberts rules based on British law is treasonous as his past namesake. Well, we don't want any violence. We don't want any death. We don't want any, political activism in that vein. But yeah, selling out your country in favor of foreigners is not a good thing. We should be protecting citizenship completely. Mustang trainer, 53 million H-1Bs must go too. Yeah, because they're all temporary. They're all visa holders, temporarily here, but they all count. Have a bunch of babies, good to go. Supreme Court justices are not smarter than a fifth grader, says GM Evil Smiles. I think a fifth grader would say, hey, if somebody breaks into your house, do they get to sleep in your bed? And if once they're in, can you kick them out? Or is their bed yours now? Theirs now. Your bed, theirs now. I think a fifth grader would say, no, you kick them out. They don't get your bed. They don't get to eat all your food. They don't get to then have the benefits of anything that comes from inside the house. Like they shouldn't collect your allowance as well. Just a guy, can Trump sign an EO designating all illegals as invaders to make it fit the 14th? It's a good idea. I actually like it to say, it's actually like a hostile army. It's like a hostile invasion. So they all fall within an exception. I think that's a good idea. I think that they would probably do some analysis as how they're not organized. It's not an army. They're not coming in with weapons or something, but it is an invasion and many of them are hostile. So I think it's a good idea. Economath. Cook's jurisprudence is fine. SCOTUS just mangled it. Aliens owe sovereign obedience for allegiance to attach. Being here illegally isn't obedient. From Economath. Rob, no female tourist into the United States under the age of 40. Another good idea, or in general. In general. Giants fan in Florida. Love the show. I heard this was a bad case to argue for birthright. Could a different case be a better argument? Not anymore, right? The floor has been set. Like the rule has been set. So you can try a bunch of different cases, different, implementations, change the executive order and come try again. But the rule has been now articulated. So the floor has been set. The foundation is set. Dan, retired ICE official Gregory Bovino said the number of illegals was between 90 and 100 million. I believe it. Yeah, I can absolutely believe that number. It's been happening my whole life, my whole stinking life. It's been happening. And I'm in Arizona, so you can see what happens. Like, go to Arizona. There are parts of Arizona that don't look like the United States at all. Everything's in Spanish. It looks like a Mexican city in some locations. Drive around. If you're from Arizona, you know what I'm talking about. Anquist, what's going on? Good to see you. Thank you for the nice dono. Thanks for being here and sending us some love. Debbie O, 44 months as a membo. For some semi-good news ideas, C-based Mike Lee. All right, we'll cue him up as we come to the close here. Sandy, we can't allow the Supreme Court to be invited back for the next term. Says we have to stop this. It won't get easier to handle with a future president. Yeah, I think that's right. Like, we're in the golden age of potential immigration reform right now, like the golden age. Otherwise, after this, I'm not so sure anybody's going to have the same position. I mean, unless it gets much worse, like unless, things really start to break down. But even then, it's like we had COVID, you know, most people in the country are just like, whatever, let's go on and put on some football. And why Trump would be smart, as I have said before, to tax all Western Union transfers out of the USA. Trump needs to make it economically painful to be an illegal because it almost is 100% all about the money. Spuds, Rob, you cannot vote yourself out of tyranny. The last civil war started out long before the firing upon Fort Sumter. Our current one is finally defrosting. We need to categorize the illegal aliens as invaders and then, you know, handle them. Well, Congress could decide on other solutions on this. We want to be careful for our YouTube censors, but yeah, I mean, we need very strict immigration policies. Be controversial. You made a good point. People who choose to sit on the fence need to realize someone always owns that fence. Today, it's hostile foreign invaders. Yeah, that's a better framing than anything I said today. But yeah, it's not just a neutral country anymore. It's like not just everybody's here because they love America. We just have slight disagreements about economic policy or something. It's way different. And these constituencies are developing that are in a conquest mode and aggressively working towards that. So we got to realize what time it is. And if you just want to sit there and say, well, I like diversity, then they're going to come diversify your portfolio away from you. Birthing centers for Christian USA, loving foreigners. Yeah, maybe you strike back. You just say, okay, we're going to bring in all the, you know, Christian capitalists from around the world. Come have your babies here. Joe, time to circle the wagons and call it what it is. Speak only in terms of advancement of goals and security. Do not even entertain the enemy's opinions. Yeah, well, they certainly don't do that for us. Like there is no modicum of respect. It's like full out political war. And we saw that the last time they tried to imprison Trump, kick him off the ballot and rounded up the 1,500 J6ers. And then we see illegal aliens come into the country, murder our women and children. And then the Supreme Court says, but if they have a baby, they're citizens. Okay. Relantel, can Trump rely on the presidential oath to preserve, protect, and defend against all enemies, foreign and domestic, and tell SCOTUS to go to hell? Yeah, he could. I mean, I think there's a lot of executive power that Trump could do. He could declare this a national emergency and he could get very aggressive with it. We'll see politically, you know, how something like that might go. He might be contemplating that right now. Would they impeach him over that? What would the Supreme Court say about any of these actions? But yeah, I mean, it's like you almost need a war footing approach. It's like a Manhattan Project for territorial integrity. Relantel, thank you for the dono. Job for 9, pack the court now. Amend the Constitution for Trump so he can run again. Do everything you can. Change the rules just like they do to us. From Job for now. Got to have the Republicans jump in on that. Dan, but we were told that forever there were only 11 million illegals. Yeah, every year it's 11 million. And it never gets more than that. Yeah. Spud, since the left supports abortion, can we have illegals get them? Have illegals. Well, they may be getting them. Yeah, I mean, you know, I don't know if you can do any forced sterilization, but I think that the leftist party, is doing that a lot. Like they abort themselves into oblivion, which is why they need to bring in so many people to replace them and us. Roberts just proved that we didn't gain independence from the crown. After all, since we're still basing our law on decisions from the crown. Man, friends, thank you for sending all those in. Let's see what Base Mike Lee has to say about this. He says, okay, so here's like one idea. So some people are talking about this would be to amend the INA to clarify the classes of individuals born in the U.S. who are nationals and citizens at birth, and to provide for inadmissibility of certain pregnant aliens seeking admission as non-immigrants, primarily to obtain citizenship for a child. Yeah, so that's interesting. So that would be a good addition. Roger Severino says so close, 5-4 with Kavanaugh kind of not in the constitutional holding, favoring birthplace citizenship. Trump should immediately amend his EO to apply to territories which are not auto-bound by the 14th Amendment. Trump should keep pushing this issue wherever he can and force the court to reckon with the logic of its decision. Will they overrule the insular cases next? Territories. That was Mike Lee from yesterday. Yeah, at a minimum, it's time to limit birthright as to territories. Trump should instruct Mullen to reverse the existing policy allowing Chinese nationals to enter the Northern Mariana Islands, a U.S. territory, for up to 14 days without a visa. Yeah, stuff like that I think would be good. But the real problems, I think, here at the homeland, so not ideal. Grok, SCOTUS can come back and change. Grok, SCOTUS can come back and change its opinion. Yeah, SCOTUS can come back and change its opinion, but it's you know, the opinions will change after like 100 years. It's almost like never, like the same court doesn't go, oops, we screwed up and reverse ourselves. That would be admitting a mistake. So Amy Coney Barrett and John Roberts are not going to reverse. The three leftists are not going to reverse. So the makeup of the court would have to significantly change. And that's, you know, unlikely to happen. So friends, it's been a beautiful stream. I think we're going to pause here on the day. Let's take a look at some other comments and see if we got anything else to talk about. Couple of comments. Patriot Alpha. What's Trump going to do to the student visa holders from China? Don't know. But remember, he wanted a lot of them to come over here. And he was like celebrating that number. Like, oh, 600,000 are coming or 500,000 are coming. Social Clipper says, increase the deportations. Wendy says, so what happens to children born outside the states whose parents are citizens? Are they not subject to the jurisdiction of the states? Does that make them automatically citizens of the country they were born in? No, other countries don't have this stupid insanity, Wendy. You go to the UK, you have your baby there, and you're not a citizen of England, then your baby's a citizen of the United States because you're temporarily there. They have a jus sanguinis, so it's connection by blood, and they don't do anything as insane as we do. What's going on, Carrie B? Sounds good, Carrie B. I'm reading your comment. Amazing. Sounds good. Yeah, we love you, Carrie B. Friends, we want to send Carrie B off with some love. I think she's going to take a break from some of this madness, which sounds good. We all need a break from time to time. And today sucks, totally sucks. So Carrie B, we love you. Thank you for everything you've done as an amazing mod. But if you got to take some time off, I hope we see you back at some point in time. Of course, stay in touch. But a break is okay. Yeah, a break is okay. Yeah, we understand. The Veil, what's up? Talking about domiciles and computers and Microsoft Windows. And thank you, See the Veil, for that. Sergeant Bob says, now the priority must be to deport as many people as possible. I think that's right. Dan, talking about the Declaration of Intention, said, my grandparents came to the USA in 1909. Grandfather needed to file this form every 7 years to register for the draft and more. Thank you for that, Dan. Humble Satellite Boy, one most revered professional judge just exercised their elite judgment to undermine our elections and trivialize citizenship. Monumental betrayal from Humble Satellite Boy. Mom of Many, do you remember the Australian couple who didn't realize they were pregnant and had a baby during the hurricane at Disney? They were severely delayed returning home because of the citizenship of the baby. Will an activist attorney convince them to be plaintiffs to challenge this all the way to SCOTUS? They had an uphill battle to get Australian citizenship for the baby so they could return home. This application of the law was a big problem for them. Yeah, it's a good question. So it's about Australian citizenship. I mean, that baby, if that baby's born here under this rule, it's a U.S. citizen. Simple as. Yeah, Rick D, I wonder if SCOTUS realized the logistical and administrative headache they just created. Now none of these kids can be sent back to the parents' countries because you cannot deport a U.S. citizen. It also means that the kids can't travel back without being issued a passport because a U.S. citizen cannot travel to a foreign country without a valid passport. That's right. Yeah, it's anchoring them. They're anchored in perpetuity. Mom of many, if you can rant over a missing comma, it matters. It makes it a separate and additional condition. We can connect on a much deeper level than I previously realized. I would love to revisit that rant. Exploding over this comma is very appropriate. It makes it a separate condition. It's not like just like born here and blah, blah, blah. It's a separate mandatory meaning. Mo Grandma, if birthright rules against us, it's more important than ever to deport and not allow pregnant women to come in as visitors. Hoofer, suddenly there's a rash of requests to have people have their babies induced today. That was before the decision dropped. And Liberty said, I think I'm going to be disappointed. It was a good call, Liberty. Yeah, it's a bummer. It's a bummer. But SCOTUS has made their decision. Let me see if Trump has said anything else on this one. And then we'll wrap on the day. Yep, there's his comment. President Xi celebrating. And the great country of China on their massive birthright citizenship win. And you know that the leftists are just celebrating and salivating all day long, which is a bummer. But Trump celebrating some of the others. Big win, ruled against men in women's sports. Just the news, the president shared an article over here. I think that was before the decision dropped. Yeah, so that's an old article. So, all right, friends, we'll pause here on the day. We got Steve Joe, no-fly executive order for non-American pregnant women. Would that be legal? Yeah, I mean, I think that you can, like, when it comes to visas and restricting visas, like, granting permission to come into the country, I don't know the intricacies of that, but I do think that, I've heard Rubio talk about it. He's like, you're a guest. We can decide who wants to come in and not come in. So I don't know, I'm sure Congress has some say in what has been set and what some of the limitations are on those things. But if you now think it is a national security concern or it's not in furtherance of American interest, I would argue that, yeah, you could absolutely make that part of your analysis, especially like with the Chinese. And, if they come in here, drop a baby off and turn right around and then go back to China, how is that serving American interests? Neuro D, man, thanks for sharing the link. And boy, we got that thumbnail right today, didn't we? Right there. Clarence saving America and these two on the opposite end. What's up? Entry regard. Deport all. Make sure they can't come back. Everyone born here needs to be charged and prosecuted if they've committed crimes, and time to go. Wendy, with few exceptions, SCOTUS despises America. I've got nothing else to say about that. CR, SCOTUS got it wrong. The 14th Amendment was a result of the Civil Rights Act, and shared a link over on X. Hopefully they rule alongside the majority of all countries on earth. They didn't. And Jenny says the decision needs to be reversed. Tectonic salt, what's going on? Man, I think it's George Washington saying a little prayer for our nation. Shout out on that one. And Deborah, sad day indeed over on X. It's a bummer. Yeah, it's a major bummer. We were hopeful that if it was going to be bad, it wasn't going to be this bad. It's bad. Hey, and Mustang Trainer, many might be shocked how even Fargo, North Dakota is full of other foreign nationals. Yeah, and did anybody vote on that? Like, did Fargo or Springville or any of these places vote to say, we'll take all these people, bring them into our nation? Or did it just kind of happen? by our so-called elected officials. Vita Brava, make them sign away birthright to get visas. Yeah, I mean, you could say you're not going to have your baby here, but if they do have their baby here, I could see a court just saying you can't contract away your constitutional right, So that's the problem. Like the Constitution is like anchored in there. It's like sign away your Fourth Amendment right so that the police can abuse you or something, or whatever. You could contract away many rights, like your free speech right, like you go and become a professor, you can't use your free speech all the times you want. So maybe you could, Vita Brava, if they wanted to get in. But that's the decision today, my friends. We'll hold off on the others since, it's kind of one of those days. But we'll pause here for the day. So we got to go through it together. Not a decision that I wanted. I'm sure not a decision that you wanted either. But we have no choice but to continue on. We have one country, and in many other domains, we are winning, and we will continue to win. And we still have a lot of the Trump presidency still ahead of us. And so we'll see what they come up with next. But I'm sure that they'll have some other mechanisms up their sleeve. So we do need to stay engaged as much as we can. I know that these can be very deflating days. I feel it too. But if we abandon ship, then we just cede the territory to the opposite side. And these people are marching on and more. So, yeah, not good. All right. And if you know somebody who's very upset about that, send them some love because it's a bummer. But all right, let's pause here. I think we had a good stream together. I really appreciate you joining us, and we'll come back tomorrow. We'll pause here for the day. We'll come back tomorrow. We have an event going on tomorrow. So I'm not sure what our schedule will be tomorrow, but we will be back on the next one, whenever that happens to be. So I'll keep you posted. Tomorrow we've got an event. There's a national security event going on. So we'll be heading out over there. Otherwise, my friends, we'll pause here for the evening. Once again, thanks for joining us. I do hope that you have a good rest of your day in spite of this news. We have to stay positive. We have to stay on the path to righteousness, and we'll have other big wins in the future. So, and it's really been an honor to be able to go through this together with you so that we can all process together. And yeah, here's another one that just dropped as we close it out. This one says from Anquist, a constitutional amendment ending birthright, attaching reparations for descendants of slavery, making the reps heroes and the Democrats hypocrites if they don't vote for it. Yeah, so I see. So attach something onto the amendment that would be extremely aggressive, and then the Democrats will vote for birthright reforms. Yeah. All right, so we'll pause here. Once again, thanks for joining us. It's really an honor to spend this time with you, even if it's on kind of a rough day. So we'll pause here for just a short while. I hope the rest of your afternoon and evening are amazing and you're doing something fun, maybe getting outside, getting some fresh air, shaking it off, spending time with the real important things, our family, our friends, the people that we love, and then joining us the next time because we'll be back to get into it again. We've got big thanks to our amazing mods and meme smiths. Thank you so much to Donut Mind Me, to John McGarvey in the house. We got Muffin Rando, K Bean, Carrie B, Neuro D, Janik, Dog Digger, Geegum Geegum, Elliot, and just Rhonda, all modding the fort down for us, keeping things nice and orderly. And my friends, thank you once again for joining us. Thanks for subscribing to the channel. Thanks for being here and joining us. We'll come back on the next one and get into it again. But until we do, I hope that you are out there getting after it, making it a great and beautiful day, accomplishing all the things you set your mind to. And you come back to join us on the next one, because in order to do this appropriately, we are going to need to see you right back here so that together, with your help, we can shine that big, beautiful spotlight of accountability and transparency down upon our system with the hope of finding justice. Make it a beautiful night. Sleep very well. See you right back here on the next one. Bye-bye.
Thanks for watching, my beautiful friends. Now it's that time where the stream must end. You brought the heat with every chat and line. Together we expose corruption. One more time we dove in the truth where the media hides. Lit up the lies with receipts on all sides. The fight isn't over, but we made them sweat. We ain't done yet, no, not just yet. Because together we are watching the watchers. Truth on our side. Watching the watchers. We won't be denied. Watching the watchers. Eyes open wide. Fighting for freedom with nothing to hide. Drop a like and don't forget to share. And bring a friend who's ready to care. Tomorrow's lies are just today's news, but here we see through